You give all order 41.
Application order for
First order 41. Give all order 41 first. Give all the applications.
My lord, I am mentioning
Just
one
wait,
matter.
wait. Are you in hurry?
Yes, yes.
Are you in hurry?
No, no, my lord, after
Just
filing,
wait.
I am giving the number of application.
What? Give application.
Great.
Give all the applications. Give all the hearing matter. Hearing matter, please give. Extension of interim order. Still many mentioning. If you mention order 41, application or hearing matter, rejected. Now up to you.
My lord, with the leave of Honorable Justice Biswas may be permitted to mention a single bench matter, my lord. This is
Not
the
possible,
DVC.
madam.
My lord, only one short point.
I tell you very frankly, because I will not be available from Friday. I am going to hold a circuit bench.
My
at
lord, I
Tandon.
understand. Only one short
So,
point, my lord. The
only thing
investment
is,
proposal has now been
let me
submitted.
come back. Let me come back. We'll mention the matter. We'll consider it.
My lord, kindly allow me to at least submit this paper. My lord.
What paper?
My lord, we are now only
Can't-
seeking
we can't
modification
list the
of the
matter.
period of the
It is
order.
only
My
for
lord.
your satisfaction. We will accept it, but
My
it
lord.
will. We don't know where it will go. 15, 17 days. I will not be here.
My lord,
I
will
will
come
be
back
holding a
after that.
circuit bench. That's why I say come back. Let me come back. Mention.
My lord. My lord, we are permitted to mention one matter of item number 84 of today's list, my lord. My lord, here, my lord, the appellate court was pleased to send the suit, my lord, on remand and with an opportunity to the plaintiff to pray for recovery of possession, my lord. It is a suit of 83, my lord. My lord, your lordship urgency is that, my lord, the learned court below, my lord, is proceeding with the suit, my lord, since the matter.
Suit or execution?
No, my lord, suit. Because, my lord,
Remand.
yes, my lord,
Yes,
because
good.
with the liberty to pray for recovery of possession, my lord. After one, it is a suit of 83 in the year 2000.
What was that suit for?
My suit for declaration and permanent injunction, my lord.
Okay.
And your lordship kindly consider, my lord, the urgency is that, my lord, the learned court of
We'll consider tomorrow. Yes.
I'm grateful.
Give the
item
note.
number 82, I have to move today, my lord. Against the ad interim order of injunction, I preferred appeal. Interim order till my lord Thursday. Now what happened, my lord? Now in a suit for partition, now my lord, the basic concept, filing of the right is that, my lord, he is one of the legal heir. Now my lord, he has annexed some documents. Now my lord, from the corporation record, it appears that the person from whom he is claiming, that person died before his birth. And now, my lord, kindly visualize, if we not move before Thursday, my lord, if the interim order extend, kindly hear them.
Tomorrow, give the notice to the other side if there is any caveat.
Yes, ma'am. 82.
Yes,
May I
82,
also kind-
82, 84 tomorrow. Next.
May I also kindly leave to mention, my lord, this matter, my lord, this is not in the list. My lord, what happened, my lord, in this matter, my lord, already one order has been passed directing, my lord, the Registrar General, my lord, to, may I place, my lord, the order?
What?
My lord,
To
Registrar-
what?
my lord, directing the Registrar General, my lord, to encash the fixed deposit and make payment proceeds thereof to the claimant.
Correct.
Now, my lord, what happened, my lord, before this appeal was taken up in this order, the advocate on record expired. My lord, the new advocate on record, my lord, he executed
Take out an application.
my
Then
lord, that application has been, my lord, I have given this only to
Firat diye dao, reject it.
May I be
Reject it. Firat diye dao.
my lord,
Why you are mentioning?
my lord,
When we
because
say
of the only-
application, please give without knowing that what is that. Why you are mentioning?
application
For your persuasive appearance.
my lord, this is not-
Sorry, we can't.
I have some urgency, though I am mentioning one application, it is running in the list as item number 215. My attachment, DM Banglo would be attached, in a land acquisition proceedings. My appeal is pending. Only, I'll deposit the decretal amount.
Why you did not deposit there in the executing court? Why you did not?
It's already difficulties.
No
It's
difficulties.
already vested land under West Bengal.
Whatever. We are not going to
So,
see that.
kindly take it up tomorrow, my lord. I will deposit the entire decretal sum before the Registrar General.
Nothing.
Well,
What is the value of the DM bungalow? You will not take prompt steps.
Just a wasted land, it has been
Sir, why you did
suppressed.
not, when
It
you
has
filed,
been
what
suppressed,
is the number, item number?
215.
250. What you were doing since 2018?
And I know, my lord.
What you were doing? This is an appeal which you filed in 2018 and now in 2023, urgency arises because you are waiting.
The then learned advocate who was
Sorry,
conducting.
if
my
you
lord, I
have
can't
inherited, if you have inherited the asset from the erstwhile advocate, you should also inherit the liability.
Now, my lord, property of the DM, my lord.
Whatever, what you were doing from 2018, why you did not immediately take out an application and move it? You did not. There was no absolutely the promptness shown from your end. And suddenly then you started saying attachment. Why you allowed the execution? Why you did not deposit at that point of time?
It has not been even admitted.
Sir, FAT is not
It's
required to
our
be
fault.
admitted, sir.
Uh,
Sir, if you have inculcated this sense that the FAT is required to be admitted, I am really surprised.
It's automatic, my lord. It's
So-
automatic, my lord.
So,
My lord, at the time of my lord, first hearing, my lord, usually there is a direction.
18 application file করেছে আজকে urgency. After 5 years, he was just waiting. PM bungalow attached. Give notice to the other side.
My lord,
Give notice and then it will appear on Friday, Thursday.
My lord.
I'm mentioning a small logima matter, my lord. My lord, there is only one mistake, my lord. I have given the slip in the application bunch, my lord. This is the application bunch that is there. My lord. This
What logima?
logima, my lord, substitution within time.
Within time.
My lord, there is an order. ওই ইয়ের আছে
Logima within time to be mentioned করে দাও, it will go to the logima bench.
লজিমা ওই
দিয়ে দাও।
অ্যাপ্লিকেশনের বাঞ্চে আছে অ্যাপ্লিকেশনের বাঞ্চে লজিমা নাম করে আছে এটা অ্যাপ্লিকেশন
Yes. Why don't you go and mention before the logima?
there is an order I have there has order has been passed in September last that it will be placed before the bench मतलब
देखिए now, देखिए नहीं. Yes, next.
It is subject to your lordship.
Call the
and
max.
sanction.
May I have your lordships kindly to mention a matter? The appeal is filed challenging the ex parte order of the learned judge, Alipur Court. The urgency is that the learned judge has passed an ex parte interim order against our clients.
What for what the mentioning?
Your lordship, for inclusion in the list, your lordship.
As
As
under what heading?
first appeal, your lordship.
First appeal.
First miscellaneous appeal.
For what?
For expeditious hearing, your lordship.
Expeditious hearing. We don't have a
Lordship-
determination, FMAT.
Lordship,
It has to go to the single bench.
lordship, it's an appeal from order, your lordship.
True. So every appeal from order has to be heard by the single division bench only for admission. After admission, it will go before the single bench for hearing. Yes.
You are subject to your lordship and sanction. My lord, may I mention one matter, my lord? Item number 199 of days list, your lordship.
Yes.
Your lordship may kindly remember, my lord, this matter was taken up by your lordship, my lord. And your lordship was of the view that there was a report of stamp reporter that whether appeal or first miscellaneous appeal will lie.
Yes.
So your lordship, my lord, later on, my lord, your lordship was of the opinion that your lordship also are not sure that first appeal or first miscellaneous appeal will be applicable. So, my lord, in alternative, my lord, we have filed an application under Article 227, my lord. But the honorable
I correctly remember Mr. Bhaskar Ghosh was appearing.
my lord, grateful to your lordship, yes.
Oh, so he has mentioned twice. The matter would be taken up serially. Don't worry.
No, your lordship, what I am on, my lord, we are.
We will call for the record. Don't worry. You
No,
need-
honorable, my lord, revisional court said that if your lordship pass an order that his lordship will be able to take up the matter, that is why, my lord, his lordship is not
Let it
taking
be-
the
let it
revisional
be
application.
taken up. Let it be taken up. We'll consider. Yes.
My lord,
Lordship-
may I, my lord, mention that before the honorable court, your lordship view
I
is
can't
this?
give you a leave, madam. We can't give you a leave.
No, your lordship, my lord, his lordship view is that is why I am submitting before your lordship, my lord.
If the matter is taken up, we will consider this. Don't worry.
As your lordship, I shall mention that, my lord.
Yes.
Lordship, may I
As
be
your
permitted
lordship, get to your lordship.
upgradation of a contempt application?
No, sir.
The original order was passed in 2021, Lordship, and the petitioners.
Sir, this matter was, I think the entire application was called at least twice in a month. Last month.
Regarding
So,
that, I have no
You
instruction.
did not.
Lordship.
Sorry, it will be called serially. Yes.
Your lordship, may I mention one matter? Your lordship, this is a WPCT matter and we have filed a recalling application, your lordship.
Recalling of,
Calling of the order passed by your lordship and in presence of Rabindranath Samanto, Honorable Justice Rabindranath Samanto. It is, we have.
then
sent
we'll
a
have
letter
to,
for
then,
assignment, your
then
lordship.
assignment has been done.
So, the Secretary of the Honorable Chief Justice has said that this matter is to be mentioned before your lordship, who has leaded the matter in the.
It is
article of-
only in case the determination is with us, then we can, otherwise we can't. We'll talk to the office. Yes, call the list. The judgment of the judgment and decree passed by the trial court cannot be sustained. Judgment and decree is hereby set aside. The matrimonial suit is dismissed.
We allow the appeal and set aside the judgment and decree passed by the trial court.
My lord, I am grateful. Thing remains, lordship. My client is required some financial assistance. There was an order. Lordship,
I appear for the ECL, my lord. There was an interim order, my lord, directing us. Order must be merging with the final order, my lord.
10,000 rupees per month has already been granted as monthly.
lordship,
Yes.
I'm for the appellant. We thus do not find any merit in instant appeal, nor in involvement of substantial question of law. The appeal is dismissed.
Must. Must.
Yes.
My lord, what happened, Lord? I am the appellant. Lord, at the time of order 41, Lord, I filed an application for recording death of respondent number 1, saying that her heirs are already on record as respondent number 2 and 3. And your lordship at the time of order 41, are pleased to allow that application. Now injunction, when the injunction matter was going on before the trial court, a single bench, then the learned lawyer for the respondent pointed out that respondent number 1 as a presided son and as a heirs. Then I filed an application for addition of party. Then your lordship kindly see the order dated 29th of August 2022, passed by the learned single judge, saying that as your lordship was pleased to allow the application for recording death, therefore it must go to the division bench. Because Justice Vishwas will not get the order of, on the other day, I handed over the order. You'll also going to take it, the order of the single bench.
যখন মেনশন করেছিলাম দেওয়া ছিল স্লিপে, দিয়েছেন?
29th of
August 2022. When I mentioned about your lordship was pleased to ask me to bring the affiliated rule. Chapter 2, Rule 1. This is business possible. Just to business. Second provision only says the division bench at the time of order 41. All other matters are before the single bench.
yes.
Therefore, your lordship at the time of order 41 allowed the application under the second proviso of the appellate rules. Now, I felt what convinced before his lordship, if Lord, I made a statement that the heirs are already on record. But if it is found that the heirs are not already on record,
No, some of the heirs are not on record.
no, even not any of the heirs not on record. But I made a submission that the heirs are already on record. Your division bench allowed this. And if I go after to the single bench and saying that is a wrong statement, you now add them party. Because then question of abatement comes in. In that case, that might be that division bench, you go to the before division bench. But here the heirs are already on record. The two heirs are already on record. But I failed to appreciate his lordships. This should go to the single bench.
Everything, it's an independent application for addition. The court will say that whether that is there or not. Abatement does not arise because some of the heirs are already on record.
I failed to convince his lordship. It may happen that I may not know the name of some of the heirs. Then this is a simply addition of party application, not modification of the order of the division bench. If it is a modification of the order of the division bench, then I have to come to the division bench.
True. True.
It must go to the single bench.
By an order allowed the said application unearthed that left some heirs and requisite. This is an application for addition. Recorded the factum already in record in my recalling the order. ও ভাবছে যে যেহেতু আমরা বলে দিয়েছি the heirs are already on record, but it appears that all heirs were not on record. সেই জন্য বলছে যে তুমি রিকল না করলে এটা হবে। তুমি অ্যাপ্লিকেশন রিজেক্ট করে দাও। That no addition is permissible. He will take care of that. এটা তো দেখতেই হবে on that. বেঞ্চ বলে থাকে যে heirs are already on record, তখন তো এটা রিকল করবো কেন? রিকল
If that statement are wrong, no heirs are already on record, then the question may arise because abatement
No,
question of
I
abatement comes
understand.
in.
Suppose if the statement is made that the heirs are already on record, the court has proceeded.
Yes.
Now subsequently, if an application is taken out that add certain other heirs, the
This is simply addition
has
of
to
party.
decide
Yes.
and say, I will not add them. At best, it can say that you have taken a stand, we will not go to add it. But why the order to be recalled?
Cannot be. But if I say that the heirs are already on record, but if that is not correct, then the question comes in. But here, this is not the fact.
Whose death?
Respondent number 1, 2 and 3 are already on record, 2 sons. And they say she has a predeceased son.
Respondent number 2 and 3 were some of the heirs,
2 sons
2 sons.
of
Now,
respondent number 1.
now addition is of a predecessor.
Predeceased sons.
Yes.
Yes.
Add করে দেওয়া উচিত। And the state of the respondent number 1 is sufficiently represented by these 2 heirs.
Yes. Yes.
So the question of leaving out does not arise.
No.
If they have any grievance, they may come at the latter stage.
But as they are pointed out, then I file an application for addition of party. As the respondent has pointed out that she has a predeceased son, living his widow and a son, then I have to file an application for addition of party. This will come very often.
Suit file করলাম যেখানে বললাম যে এরা হচ্ছে ওখানে as a heir of this. Defendant is also they are not the heirs, there are certain other heirs. On the basis of the defendant's plea, certain other heirs, thorough addition shower. Can I not seek? Always. Always. The complication করার কোনো মানে হয়? এটা রিকলিং কেন হবে? এখন লিখতে গেলে আমি উল্টো পাল্টা লিখবো।
The lordship passes on because this matter will appear in many cases. Addition of party always been done in such a case, if some of his heirs is left out.
That's our experience over there as well. Take an
Only case of
instance,
abatement.
take an instance when a suit for partition is filed. One of the co-sharer died. His heirs say 3 persons have been has been implemented as a party who succeeded to his share. Later on, some of the defendant, he pointed out, no, they are not only the heirs. There are 2 daughters also who have inherited. Cannot the court allow that addition? Bringing those 2 daughters. Similarly, if you are not aware of any other heirs, you have said that you have been implemented. At that point of time, because the respondent number 1 was implemented along with 2 and 3 on the basis of their predecessors' right. Is it? 2 and 3, why they were implemented? Because
The predecessors, right?
all 3 of them. If there is something more, then why not?
I could not convince his lordship. I said, if it is a question of abatement,
Have you shown that chapter 2, rule 1?
no, that at the time of hearing, suddenly his lordship has said this.
And for the restaurant.
I had no scope to that. I specifically said, his lordship, if the question of abatement arise, then this question may arise. But
True.
there is no question of abatement.
No.
Therefore, this does not arise this question. This is simply application for addition of party. And I do not, as my learned friend pointed out, then I came to know he has, as if this is his son. I do not know that.
And they were not opposing
No.
the addition because they pointed out that
They
they are
pointed out.
left, so they are to be made a party.
When injunction application was going on hearing, then they pointed out. And they give us the particulars and we file the application for addition of party.
One of the legal heirs of the.
Sir, we have understood. The question is whether the order of 29/8/2022 can we accept or we should not accept.
On this one, there should be a specific judgment, otherwise, because many cases will come on this.
Now, recently, yesterday, a judgment has come that by virtue of an amendment under Order 6, Rule 17, you can't add any party. Of our High Court.
By amendment, party was going to be added.
Where is the bar?
No, but
Along with the
when there is a
pleading?
specific provision,
Along with the pleading.
when there is a specific
That
provision,
is wrong quoting is also not fatal.
yes,
If there is an amendment of certain pleadings, along with that, the addition is
Yes, yes,
done.
yes.
Why not?
yes, no problem.
At least I know at least two or three judgments. Where is the difficulty?
No difficulty.
Let me then make some homework, or you do homework, give some kind of a judgment. No, this has, as you said, this
Judgment will not-
judgment is to be delivered.
Yeah.
Please assist
Because
me also. I
many
will also
cases-
do some homework. Please,
many
you
cases
also
may
do
come,
some
yes.
homework and give
Many
it to
cases
us.
may come on this point.
Yes, I understand. So
That
you
is why
please
I'm-
come with some that there is no difficulty. So let us see tomorrow.
No, your lordship,
No, the difficulty would be that this matter will then be listed after 15-20 days.
your lordship give me a homework. That is a judgment.
Evening,
But
in
what
the
I
evening.
find in my truly thanking, that today morning I have also found a judgment of other High Court. I want to see the Calcutta High Court judgment is there or not, or Supreme
Do
Court
it,
judgment.
do it in the evening today.
My house lord, I will not able to get that judgment. I have to go to the study and do that. Your lordship only take it Thursday. Thursday, your lordship are there.
Yes.
So let's keep it on Thursday.
On Thursday, as to be mentioned.
কলকাতার জাজমেন্ট দেখো আমি মাইসুরের জাজমেন্ট পেলাম অন্য হাইকোর্টের আছে অ্যাডিশন অফ পার্টি করা যাবে ডিভিশন বেঞ্চে যেতে হবে আমি পেলাম যেটা আমার বই বাইরে হাইকোর্টের জাজমেন্ট আছে কলকাতা হাইকোর্টের জাজমেন্ট দেখতে চাই সুপ্রিম কোর্ট
And I appear for the appellant. I appear.
Yes. The two second appeals.
There are two. Yes.
What for?
No, my lord, but one, my lord, my cross objection was dismissed and another, my lord, the suit was,
Can you recapitulate the fact?
my lord, I had argued, my lord, 1 month back, my lord, also, my lord,
Oh.
for, my lord, if this can be taken up next week, my lord,
No, tomorrow.
or day after tomorrow, my lord,
No, tomorrow.
Thursday.
Otherwise, we'll go by the whatever.
Lord,
We'll
lord,
go by
lordship
the
had
judge.
heard it, my lord, 1 month back.
No,
but I
that's
also,
true,
my lord,
but that was not
forgotten.
admitted. If I correctly remember,
Yes.
there were certain things which requires to be gone into, some facts.
My lord, my books, my lord, today, my
No,
lord.
come tomorrow. You have a note with you.
Tomorrow.
You have a note with you.
Note is there, my lord,
Tomorrow, argue this as order 41 diye dao. Both. First matter.
কালকে appeal
Hello, this is my opinion.
But I'm for the defend number one.
What is the
defend number-
stage of the suit?
My lord, nothing has happened, my lord, after the interlocutory application has been dismissed and an appeal has been filed here.
No step has been taken by the plaintiff, my lord. Though, my lord, there is no stay, my lord.
My lord,
But why the suit is not proceeded or dismissed for default or whatever? You are also not taking any steps
yes, my lord, I have been instructed that adjournments have been taken, my lord.
by you.
My lord, by them as well.
But I have
Both
no
the
such
parties, my
instruction.
lord, both the
I have
parties.
no such instruction, my lord. But
You
my-
have?
By both the parties.
I have no such instruction, my lord, but the plaintiff, my lord, is to, my lord, proceed with the suit. My lord, since, my lord, there is an injunction, my lord, refused earlier by the learned trial court, my lord,
Let us see.
but there is no stay of the proceeding of the suit.
Obviously cannot be at the injunction stage. Can you give us a typed copy of the order?
My lord, I do not have it with me right now, but if your lordship pleases, my lord, may I just place it, my lord, perhaps? My lord, just the ordering portion, perhaps. My lord, the writing is
You
not
place
really.
it from this.
My
Please
lord,
place it.
my lord, I know, my lord, my copy is also, not in a
So-
good state.
Even, my lord, yesterday, my lord, I tried to have a copy from my hand to get it typed, my lord, I could not. I have
no,
taken
it
out, my lord, I'm at an inspection of.
And this is the original certified copy.
No, it is not,
Certified copy. Is a photocopy.
certified copy here.
How can they give like this?
সার্টিফিকেট কপি ওটা ওখান থেকে আমাদের জেরক্স হয়েছে অটোমেটিক্যালি আরো
My lord, I am aware, my lord, this is not legible.
And, my lord, and I've checked, my lord, it is not available in the e-court services also, that I can get it downloaded.
Why it is not uploaded on the
I
server?
do not know, my lord. I have checked, my lord, so that it can be, my lord. I can, my lord, otherwise assist your lordship, my lord. I checked it, my lord. I didn't avail it. It is not available on the website also.
Yes.
My lord, will it be your lordship's pleasure to give me some time to obtain a typed copy? Or my lord, if your lordship so pleases, my lord, may I just place what is written to the best of my ability? I know, I am aware of it, your lordship. My lord, we have made photocopies from the certified copy, so my lord, we know what the.
No, I am looking at the certified
Yes,
copy
yes.
itself.
Yes, my
One
lord.
thing
We
is,
know,
my lord,
yes.
The
photocopy.
photo state certified copy,
Yes,
which
my
is
lord.
like that.
Yes, my lord. No. Lordship,
What is the suit for?
My lord, the suit is for recovery of possession. My lord, I am led by Mr.
Suit is for
My lord, recovery of
recovery of
possession.
possession
Yes, my lord, as well as
against
for
you or by you?
No, I am the plaintiff.
Yes, recovery of possession on what ground? Yes, let us say the fact.
Yes. My lord, recovery of possession on the fact, my lord, my plot of land, my lord, was a vacant plot of land. My lord, the defendant number 1 is the owner of the adjacent plot of land. My lord, I did not reside there. There was no building or structure there.
It's a vacant land.
Yes, it's a vacant land. My lord, I come to.
Not protected by any boundary
Yes, my
wall.
lord, there was a boundary wall.
Okay.
My lord, we come to learn, my lord, we have purchased the land in the year 2008. My lord, we come to learn around 2015-16, my lord, that the boundary wall has been broken, and my lord, he is the owner of the adjacent plot. My lord, he demolishes the boundary wall. My lord, he encroaches upon my land. He starts construction. He builds a one floor pakka structure with tin shed. And my lord, then he also proceeds to sell a part of my land through a registered deed. To defendant number 2. My lord, the defendant number 2 here. My lord, when I come to learn of this, my lord, I file a suit. My lord, I am not only the recorded owner, my lord, I also pay my tax. I have a proper title deed. And my lord, at the present moment, my lord, the latest, at the time of filing, my lord, we had taken out information of what the particular LR plot, my lord, who are the owners and Khatiyan numbers. My lord, there it reflects that my portion of the land remains intact. I have not sold anything. But my lord, the actual situation lies, my lord, he being the owner of
Did
14
you ask for a
decimals.
commission?
My lord, we have asked for no further third-party rights to be created. And my lord, change and nature and character should not take place. My lord, that was our plea, because my lord, already 1 acre has been sold from my plot of land. However, my lord, very strangely, my lord, on pen and paper.
You not ask for any commission?
No, not at that stage.
Not at
No, my lord, we are coming up against a refusal of an order of injunction.
Madam,
We have not. We have not.
when there is a dispute as to the extent of the property, then what is of proper course?
Yes, my lord, we have not done that. That we have not done. And my lord, the
Why the court refused?
my lord, the lower court says, my lord, he is not satisfied that the prima facie case has been built by me.
Why he is not satisfied?
My lord, he says that he is unable to form an opinion that I am the owner or he is the owner. So therefore, he says that the suit should proceed to trial. My lord, that is the small portion. My lord, he says.
For that, the protection it shall not be given.
My lord, he says no. He says no, but my lord, despite the fact that I have a title deed in my favor.
No, I understand.
My lord,
Difficulty is the identity.
My lord,
they have a title deed, but to what extent the property?
Yes, my lord, at least a temporary protection ought to have been given so that, my lord, no further encroachment takes place. And my lord, the fact that the encroachment has taken place, my land is also there, is evident from the latest plot details that we have obtained. My lord, my Khatiyan number, my total portion of land remains the same. My lord, out of the 14 decimals that defendant number 1 says he was supposedly the owner, that stands reduced. My lord, he becomes now the owner of 13, and 1, he says that separately. But my lord, my contention is that 1 acre has gone from my plot of land, from my 8.25 decimals.
investigation. Yes, the next year they are subjected to pending pending data. The dispute is that is what is to be further transfer perception.
My lord, my submission is, my lord, the interim protection that has been granted to us at the time of filing of the appeal. My lord, the admission.
Protection.
My lord, the interim protection was that, my lord, no change and character, no further change and character should be granted, no third party.
Changing the nature and
character, my lord, and third party rights should not be created. My lord, that should be there till the disposal of the suit, my lord. That was the original prayer with which we had approached the lower court.
Yes, what your senior now say? Anything you want to add?
Not only one, Lord, additional facts from what my learned friend has said, Lord. The property originally belonged to Lord Sukhdev Bhagat. That's an admitted position. They also say it belonged to Sukhdev Bhagat. Sukhdev, Lord, he owned Lord 67 decimals of land. Amongst that, 33 decimals of demarcated land was sold to Lord Kalachand Rai in 1980. Then Kalachand Milord, amongst the 33, sold 8.25 in 87 to my predecessor. And from him, I purchased that 8.25 in 2008. Their case is that they purchased Lord Bhagat, sold Lord some portion of land to two persons. From them, they purchased it. So they don't deny that Bhagat was not the owner. They don't deny that our deed is not.
Whose sale was your predecessor sale?
My sale was earlier, their sale was later.
Better.
Yes, and second thing I'll show you, Lordship.
So you got, your predecessor got 8.25 from Bhagat.
That is absolutely demarcated in the deed.
Correct. And then later on, the rest of the properties was sold to
Lord,
their predecessor.
9 decimals, not the rest. 33, 8.25 to me, 9 decimals to his predecessors.
So you say 67 decimal.
60, among 60 decimal, Bhagat sold 33 to Kalachand.
Correct.
From that 33, I got 8.25.
Are they denying Kalachand?
No, not at all.
They have also purchased from
Bhagat.
Kalachand? Bhagat.
I could have won.
So 8.25 decimal Kalachand sold to you out of 33.
Out of 33.
And the rest
34.
From them, they
purchased 9.
9.
And what is more interesting, Lord, they don't, in the affidavit in opposition filed by before your lordships, they say, Lord, their plot is 418, whereas my plot is 416 in the affidavit. They don't disclose their predecessor's purchase. And they said it is 418, and they are claiming that they sold 1 decimal from 418 to defendant number 2. And the trial just says, since I have prayed for recovery of possession, I am not entitled to an injunction. Only on that ground. I have asked Lord to get a typed copy. I can read it for your lords. It's very difficult to read. But only on that ground that I have prayed for recovery of possession, so I am not entitled to an injunction. And the Honorable Division Bench protected my right that there should not be third party interest created, and there should not be any further injunction, further construction. Lord, we can not go back and the suit may be decided. Lord, I can show you lords the deed. Lord, I have.
You have purchased 416.
Yes, that's my.
And their contention is
No.
418.
In the affidavit in opposition, I'll point out the paragraph. In the affidavit in opposition, Mr. Chattopadhyay's client has categorically recorded internal page 5.
418.
418.
That's why I'm saying.
I pointed out.
418. They're claiming title. You are claiming title in 416.
Well,
is it true? Is it true, madam?
Yes.
These two plots are side by side. These two plots are adjacent one.
True.
We have
so the adjacent owner has a lien or a privilege or a preemptive right to encroach upon the adjacent landholder.
My purchase was made in the year 2001.
Correct. And their purchase predecessor as Kalachand was purchased earlier.
We both
Kalachand purchased
87.
87. Yes.
No, 1980.
My lord, in their deed, my lord, there is no, my lord, recital of my lord where from they have got it, my lord. Only
no recital.
Lord, kindly come to page 4. Page
Sir, don't worry. That's the fittest case for a relay and survey of the property. And till that time, you shall not, because you have already divested one interest.
I will not, my lord,
You will not, and nor will make any construction there.
No, my lord, I have, my lord, got the sanction building plan from the
Yes.
panchayat.
Yes.
I have, my lord, made a boundary wall. I have started, my lord, when it was, my lord, on the.
No, it is only in respect of a disputed plot of land
No,
of
not in dispute of the, not in.
1 acre, which he claims you are owner of the rest. You can continue, but this 1 acre that should not be done adjacent to.
No, my lord, my sanction
No,
building
my lord,
plan.
he has taken the entire land, sold not decimal. He has taken the entire land 8.25.
But I have, my lord, got the sanction building plan from the panchayat, my lord. The moment, my lord, so far, my lord, the creating third party interest, my lord, I have no issue.
We will say that there should not be any construction or any kind of change so far as 416 plot number is concerned.
My lord, 400, my lord, I have, my lord, kindly see.
You have purchased 418. Be restricted to 418. There should not be any construction on 416,
My lord,
which you do not own.
my lord, I have purchased.
Am I correct? Where is that paragraph where he says
Affidavit in opposition, internal page 5.
5? Show.
Lord, kindly start reading from paragraph, page 4, last paragraph. My lord, kindly got it, Lord. As a matter of fact, I purchased the plot
No,
of.
418. He has said.
Yes, 400, he has said.
In a schedule 418.
Yes, and Lord,
And your claim is 416.
16, that's my.
That's all. Finish.
Yes.
Injunction on 416.
No, lordship, kindly come to page 65.
Yes.
Of the
I am
application.
going by your statement at paragraph 3 of your opposition.
My lord, lordship, kindly come to page 45.
Please come to page 4, what you have said of your opposition. We will not go by anything. We will go by your statement made on oath.
Well, only.
Your statement made on oath. Please come.
I'm coming, my lord.
Page 4, last paragraph. Have you got that? Your opposition. As a matter of fact, I purchased a plot of land by virtue of a deed of sale, which was registered before the office of the additional registrar such and such. The said deed of sale was executed and registered on December 21, 2000. The schedule of the land is specifically mentioned in the sale deed is as under. All that the piece and parcel of land measuring 4 katas, 4 chitas, 0.0 acres within Pargana such and such, Tauji, PS Siliguri, such and such, Darjeeling, recorded in a new Khatian, included in new plot number 418. That's all.
Yes. Then, my lord.
If you claim 418, we are not saying anything on 418. Since you do not have any right in 416, you are injuncted. You are injuncted.
My lord, only one thing, my lord.
That's all.
My lord, the sanction building plan, my lord, the sanction building plan, which
Was 416 also. Tell us, we will make an observation. Don't worry, sir. Tell us that sanction building plan encroaches 416 as well. Sure, sir.
just allow me 2 minutes.
What did you lagan? 2001 deed you have never produced.
show us a single document where any right in 416 is created in you. One document. I got your opposition at page 31.
That is,
I have seen subparagraph H of paragraph 10 at page 31. Show us a single document. Any title deed.
That's also a part of the petition, not page 97. Page 98.
I just wanted to. What is it?
Record of right about
Page.
That's the record of right.
কেসটা মেট আউট করছে
but originally,
416 উপরে কেস মেট আউট করছে
It's not the-
my lord, I can.
একটা ডকুমেন্ট দেখে 416 তুমি পেয়েছো তোমার পজিশন আমি বুঝতে পারছি সেই জন্য রিকভারি অফ পজিশন চেয়েছি এই জন্য তো চেয়েছি Sir, one document. I am ready to accept.
But I can produce the deed. My lord, supermarket.
Yes, you have produced the deed. You have shown the schedule. Schedule says 418 only. 416, show us.
418, my lord, plus it can be my lord. For the construction part is concerned, my lord. Let it be, if it is not within 418, my lord, there is no problem.
No, we are saying so. He can't lay any claim.
I don't.
Sir, your case is very interesting. At page 31 of your opposition. Very interesting case you have made out. That's why I asked you to produce. You are trying to lay your hand or stretch your palm or a hand to 416. What is your authority?
My lord, that is not permissible for the my lord, the people, my lord, defendant, my lord, to my lord, extend my lord beyond 480.
You have. You have.
My lord, let me produce my lord.
You have, sir.
Let me-
Have you read? You have not read the
My
brief.
lord, my lord, there is, my lord, they have purchased my lord from one Kalachand Roy. But my lord, original owner Sukhdev Bhagat, my lord, he is my lord, original owner.
Sir,
After,
I
my lord,
am,
it was transferred,
sir,
my lord,
don't go by this. The law is well settled. The original owner, the Bhagat, they owned 67 decimal of land. In 1980, they sold 33 decimal of land to Kalachand. Well demarcated portion which they sold. The Kalachand in turn sold 8.25 decimal of land to the plaintiff. Now it appears that in 2001, this Bhagat sold you 9 decimal of land, which must be beyond 33 decimal of land, which he has already sold to Kalachand.
original.
Now again, here it appears that what the Bhagat sold to you was 418 LR plot number. Now, they say that you have encroached a one decimal of land
1 decimal
in
sold.
416.
Yes, sold. to
You have
the-
encroached 1 decimal of land in 416. You have said, very interesting at page 31. H, very interesting case you have made out. Read loudly and tell me. You are not restricting your right to 418. You have encroached on 416. Read. Page 31, subparagraph H of paragraph 10. That's your opposition in the trial court.
এই তো তুমি তো এই তো তোমার অপোজিশন
Page 31.
এই 31 এখানেও আছে পিটিশনেও আছে
H, Sir, you have seen? Show us one document, 460.
460, my lord.
One document. I am with you, rather both of us are with you. Show us one document.
Well, I have not, my lord, in annex, my lord, the cell deed.
You have depicted the schedule, sir. I read it in your
Page
opposition
4, page 4.
at page 5. You have said you have got only one deed executed in your favor on December 21, 2001. You have narrated or depicted the whole schedule. Schedule says LR new plot number 418, area measuring 0.70 acre, Danga land sold. So 418, you say 416, show us one document from 416. Any document of 416.
May I come back, my lord, tomorrow?
What come back tomorrow? You did not have any other deed.
But let me come back.
Except one deed you did not have.
And the defendant number 2 is not coming before your lordship. He sold one decimal to defendant number 2 of 416. He is not before your lordship, despite service. He is espousing the cause of the
Tomorrow,
transfer.
Can you pass order tomorrow? Let me come back, my lord, tomorrow.
Nothing.
They have made construction after the order also. We filed a contempt. I am not pressing that. They have made construction even of the order of the division bench. I filed a contempt. I am not pressing that for the moment.
Why you are not pressing it?
Because, my lord, that if I press the contempt, it will have to go to, my lord, the bench, my lord, where Justice Saraf is a party. I am not pressing that.
So go
No,
there.
but I am not pressing that. Can you decide the appeal?
No.
But I am not pressing that. I am not pressing. Can you decide the appeal? Can I record my undertaking that I am not pressing the contempt, I am withdrawing it. Can you decide the appeal?
You are injuncted
Yes.
till the disposal of the suit. We are expediting the disposal of the
Yes.
suit.
So far, 416 is concerned.
416.
Lordship, make it clear, my lord. If it is on 480, my lord, there will be no bar for construction.
No, I am not
416.
yet for
And we will also make, if any construction which has been made on 416, the trial court will go and pass a decree for mandatory injunction for demolition thereof.
But my lord,
And nobody will claim any equity thereupon.
Lordship, kindly.
Have you prayed for any mandatory injunction?
But I have, just a second, kindly give this.
Yes, permanent injunction.
Yes, I have paid for,
Mandatory injunction.
just a second, note, injunction page 88. Lord, the prayers are at page 92, temporary injunction, restraining defense examination from alienating, restraining third party, also from changing the
The
nature.
plaint what
No,
you have prayed, have
No,
you
no,
prayed
no,
for any mandatory?
we have prayed for recovery of possession, perpetual injunction. Lord, we will amend it and pray for it. For the blood, that is not done. Lord, may I take a lordship leave? But kindly, Lord.
When the injunction is granted by this court?
Eta bolo na order, division bench order. My lord, 24th October 2017.
And it is still operating.
Yes. My lord, it was
Yes,
till
my lord, there is
disposal of the-
nobody. There is nobody.
till the disposal of the application.
কোথায় আছে?
24th October 17.
The instant appeal arises from the judgment and order dated uh, 3rd June 2017, passed by the learned Civil Judge Senior Division Siliguri in title suit number 53 of 2016, whereby and whereunder an application for temporary injunction was dismissed. Stop. A suit for declaration of right title and interest in respect of the suit premises and permanent injunction restraining the defendants from creating any obstructions or making any changes in the nature and character of the suit premises, along with an prayer, along with the decree for recovery of possession is instituted by the plaintiff appellant. Stop. It is a word in the said plaint that originally, what is the full name of Mr. Bhagat?
Sukhdev
Bhagat.
Bhagat.
That one Sukhdev Bhagat owned and possessed 67 decimal of land. Comprised in RS plot number 94/180 in Mauja Thiknikata Police Station, Matigora, District Darjeeling, on the basis of a deed of sale number 2137 dated 10/4/1964. Stop. Subsequently, the said Sukhdev Bhagat sold, transfer and conveyed where is the concept of Kala Chand? It says some Mihir Gupta.
My lord, that is their,
Oh,
Well, we have got it from Mihir Gupta and Madhav Shah.
no, that's just 1 minute. This is their opposition.
yes, your lordship.
Where is your plaint? It is at page.
20
Yes.
of the stay application.
দেখো ঠিক আছে, ওটা ঠিকই আছে। The said সুখদেও যেটা আছে ঠিকই আছে না, বলেছি সুখদেও ভগত sold, transfer and conveyed 33 decimal of land to Kalachand Rai by executing and registering a sale deed bearing number 1482 for the year 1980. Out of 67 decimal of land which he owned. Stop. Subsequently, the said Kalachand Roy sold 8.25 decimal of land out of 33 decimal of land to the plaintiff. No, it was sold to
Bulande.
Yes, was sold to Bulande with the specific with the specific boundaries. And the said purchaser possessed the same and also discharge his obligations upon payment of the taxes and the cess taxes applicable thereto. The said Bulande subsequently sold the entire land which he purchased from Kalachand Rai to the present plaintiffs by executing a deed in the year 2008. It is a plaint. It is a word in the plaint that after purchasing the said property, they demarcated. They protected the same by constructing a boundary wall.
But there is no affirmance in the plaint itself.
Which one?
Whether there is a boundary wall, whether it has been demolished.
Kindly look into paragraph 3.
I'm just looking into it.
Paragraph 3, 4.
What are you talking about, sir? Don't disrupt. The plaintiff soon after purchasing the same from the vendor have demarcated their suit land with pakka wall.
But there is no, my lord, there is no amendment for demolition, my lord, boundary.
I have not said any demolition, sir. I simply dictated that after the purchase, they protected the property by raising a boundary wall.
I'm sorry, madam.
To that extent, you interrupted, which is there in paragraph 3.
I'm sorry.
Have I said demolition?
But that was their submission, my lord.
Maybe I have not recorded. But you know the habit of interfering when a court dictates the order. কি বলেছি protected কি purchase boundary wall. As it was a bare land. Full stop. It is alleged in the plain that in the year 2015, the defendant number 1 claiming to have possessed and owned the land adjacent to the suit land, intended to encroach the portion of the suit land and make a construction thereupon. Stop. It is further alleged that after getting an information that the said defendant with some unknown person entered into the suit land without any right, title, and interest, and started making a pakka construction by engaging masons and laborers, the plaintiff rushed to the spot to the suit land and found that a pakka roof that the structure with the pakka roof up to the ground floor level has been completed, and the construction work is going on with rapid pace. It is further alleged that taking advantage of the wrong recording in the record of rights, the said defendant has taken advantage thereof and in fact encroached upon 1 decimal of land and ultimately sold it to the defendant number 2. Full stop.
My lord, may I just interrupt once? My lord, we have said, my lord, they have built a wall around the entire plot of land.
Sorry, we have seen it. I am reading paragraph wise and I am dictating in my own language. So badly, grammatically wrong languages have been used.
I am aware.
We are not going to say verbatim what the plaint is, the salient facts.
Very good. But only that, my lord, they have taken over.
Sorry, we can't. কি বলেছি এই ডিকটেশনটা চেম্বারে করে দেব because they will continue disrupting me from dictating the judgments.
Sorry, my lord.
They will never allow me to dictate in the open court. This is a new practice which has developed into the young generations,
My lord,
and
kindly
that
forgive
has been adopted by the old generations as well. When we started practicing, we never had a courage to interrupt. We were groomed in a sarista where our senior told us that please take a note if you find there is some factually incorrect words have been used in the judgment, take a note of it. And the moment the entire judgment is delivered or is dictated, you can point out those to the judge, not to interfere in the midst of the dictation. Not expected, never the culture of the Calcutta High Court. It has recently started
My lord, it's
like
my
this.
mistake, my lord. I should not have done.
And everybody is just following the suit. You can't dictate the judge to say a particular word which you think is the appropriate one. The judge in his own language will dictate.
I should not have done.
Since you have used the word cunningly, so the judge has to use the word cunningly. Why? This is not
Kindly
proper. Never proper. I tell you, we're never proper.
Kindly complete the judgment, my lord, after my lord.
This is not expected. What the juniors will learn. This is what the decorum of the Calcutta High Court, more than 150 years of such a heritage culture, such a culture of the Calcutta High Court.
Kindly complete it, my lord.
Let me come back. পর্যন্ত গেছি। On the basis of the aforesaid facts, the aforesaid these reliefs which are claimed in the plaint relates to a declaration of their right, title, and interest in respect of the suit property, and also declaration that the purported deed executed by the defendant number 1 in favor of the defendant number 2 is void and for recovery of possession. Apart from a relief for permanent injunction, restraining the defendant or respondent from transferring and or changing the nature and character of the suit property. The defendant number 1 is contesting the said suit, and it would appear from the stand taken therein that they also trace their title from Sukhdev Bhagat, who sold and transferred 6 kathas to Mihir Datta Gupta in the year 1983, and another 3 kathas of land to Narayan Chandra Gupta in the same year. Stop. The Mihir Datta Gupta in turn sold the purchased property now to the extent of 4.5 kathas in favor of Madhav Chandra Saha out of 6 kathas in the year 1996. Full stop. We need not have to narrate the full facts for the reason that it is a specific stand of the defendant number 1 that he acquired the land comprised in new plot number 418, which would be evident from the schedule appended to the deed of sale dated December 21, 2001. The only question arises in the instant suit whether the defendants have acquired any right, title, and interest in respect of plot number 416, which the plaintiff claimed on the basis of the deed of purchase. To stop. Our attention is drawn to the affidavit in opposition filed to the injunction application. Sorry, next paragraph. On the conspectus of the aforesaid facts, the application for temporary injunction was taken out, and an ad interim order of injunction was granted by the trial court. Stop. By the impugned order, the trial court dismissed the application for temporary injunction on the premise that the moment there is a dispute as to the extent of the property purchased by both the parties and a decree for recovery of possession is sought, no injunction should be granted by the trial court. It appears from the affidavit in opposition to the application for temporary injunction filed by the defendant number 1 that the defendant number 1 has categorically stated that their name has been recorded in the LR record of rights in relation to the LR plot number 416, and therefore they have acquired the right, title, and interest in respect thereof. It is further contended that the building plan was sanctioned, that upon obtaining a permission from a panchayat for construction of a house, the construction is being made, and therefore the plaintiff is not entitled to any temporary injunction pending the suit. So at the time of an admission of the instant appeal, this court passed an order, ad interim order of injunction restraining the respondents from transferring, selling, and or alienating and or creating any third-party interest in respect of the suit premises, and or changing the nature and character thereof, and or parting with the possession of the suit premises till the disposal of the instant application. The aforesaid ad interim order of injunction was passed as far back as on 24/10/2017. And it is not in dispute that the said order, ad interim order, is operative till date. Stop. The first and foremost point involved in the instant appeal, whether the trial court was justified in rejecting an application for temporary injunction on the grounds indicated therein. The dispute pertains to the right, title, and interest in respect of plot number LR plot number 416, which according to the plaintiff belong to them. The schedule of the deed dated December 21, 2021, disclosed by the defendant number 1, revealed that the LR plot number 418 was sold, transfer, and conveyed to him by the predecessor. The antecedent of the several transactions having entered into is evident of the fact that both the parties traced their title through Sukhdev Bhagat, who admittedly owned 67 decimal of land, and by virtue of a several dint of sale, sold, transfer, and conveyed a part of the said land to different persons. The schedule of the deed executed in favor of the defendant number 1 would reveal that the LR plot number 418, to the extent of the land as shown therein, is transferred in his favor by the said Bhagat. The moot question that arises in the suit is whether the land over which the constructions have been made comes within the ambit of LR plot number 416 or LR plot number 418. Though the defendant number 1 has claimed that his name is recorded in the LR record of rights in relation to plot number 416, but we do not find there is any corroborative evidence produced by him that the right title and interest in respect of the said LR plot number 416 or a part thereof has been conveyed to him. Mere entry in the record of rights neither creates any title into a person nor extinguishes the title of a rightful owner. The aforesaid entry is intended to impose a liability upon a person for payment of a land revenue, or at best can have a presumptive value or position. Indubitably, the plaintiff claimed to have lost position in respect of a 1 decimal of land allegedly comprised in LR plot number 416 and prayed for a recovery of position against the respondents. Obviously, once the position is lost and a suit for declaration of title, right title and interest in respect thereof has been claimed, we do not find any impediment in the plaintiff appellant in seeking a decree for recovery of position on the strength of such title. The dispute hinges upon the 1 decimal of land which, according to the petitioner, is allegedly sold to the defendant number 2 by the defendant number 1. And unless the court arrived at a concrete finding that such 1 decimal of land comprised in the LR plot number 416, the further relief of recovery of positions cannot be passed at this juncture. Since the defendant number 1 never claimed any right title and interest on the strength of a deed of sale dated December 21, 2001 over the plot number 416, LR plot number 416, but purchased the LR plot number 418 to the extent of land indicated therein. Any further improvement, if made thereupon, would create a immense injury to the plaintiff, and therefore we do not subscribe the view expressed by the trial court that the temporary injunction cannot be granted if a relief in the form of recovery of possession is sought by the plaintiff. Since the ad interim order of injunction passed in the instant appeal is operative for nearly 5 years, and it further appears that the defendant number 1 has already filed written statement, we do not find any impediment on the part of the court to proceed with the suit and dispose of the same within the time frame. Since the plaintiff appellant has been able to make out a prima facie case in respect of their right title and interest over the plot LR plot number 416, we thus do not find any ambiguity in the ad interim order of injunction pass against them relatable to the said LR plot during the pendency of the during the LR plot to operate against the respondent. Accordingly, the ad interim order of injunction dated 24/10/2017 pass by the division earlier division bench in the instant appeal is hereby made absolute to operate till the disposal of the suit. However, for the purpose of to avoid to remove any difficulties and or ambiguities in construction of the temporary injunction granted by this court, it is hereby made clear that the said order of injunction is restricted in respect of the suit plot, that is the LR plot number 416. Against the respondents. With these observations, the appeal is disposed of, no order as to cause.
My lord, the suit of 2016, my lord, kindly expedite it, my lord.
Lakho, the trial court is requested to expedite the hearing of the suit. An endeavor shall be shown to dispose of the same within 6 months from the date of the communication of this order, in presence of the parties or their respective counsels. It is further made clear that the trial court shall refuse to grant the adjournments to either of the parties unless necessitated by unforeseen and unavoidable circumstances.
May I make one submission? My lord had observed, my lord, if any unauthorized construction has taken place, your lordship will direct that to be demolished.
We are not going to say anything in this regard. Why we will assume an advisory jurisdiction? We are not supposed to.
Very.
So you have to take call.
Very.
What you will do.
My lord, I have filed an application of Hon'ble that can be, my lord, disposed of.
In view of the disposal of the appeal, all connected applications are accordingly disposed of.
I'm sorry, my lord.
No, never do that. I tell you the difficulty is because there is a thought process which is going in the mind that up to this, after this, there is a sequel. And the moment you interrupt, that sequence gets disrupted.
But I apologize.
Let's call the next. So many applications in this appeal.
Also, the Madrasa Service Commission
9
is the appellant before your lordships. Now, lordship, I am led by the learned Advocate General. Now, lordship, the matter is, lordship, the Honorable Single Judge matter relating to publication of the result for the post of Group D.
Group D.
Group D. Now, lordship,
what is this application for modification?
Yes. Now, lordship, before that, lordship, kindly bear me that the Honorable Single Judge, lordship, they passed an order directing the West Bengal Madrasa Service Commission to publish the result within a certain period. Now, lordship, challenging the same, we preferred an appeal. This mandamus appeal. Now, in this appeal, lordship, we filed an affidavit that this result will be published within a period of 6 months. Now, this order
the appeal has already been finally disposed of on 4th of December, 4th of February 2020. So we declined to interfere with the order. Only we modified to the extent that the period which is given.
It has been extended till 6 months.
Yes.
Now, subsequently, lordship, due to lordship the overspreading of the COVID-19, lordship, the result could not be lordship the published. No, we filed an application
for extension of time.
Yes. Now, in the meantime, lordship, we started to scrutinize the lordship the recruitment process. Now, in the recruitment process, lordship, it is seen that the Lordship, the written examination were taken in a 3 slots. Now, so far the result has been published in respect of 1 slot, and so far the other 2 slots candidates has been, Lordship, the result could not be published due to, Lordship, the difficulties in evaluating their OMR sheet. Now, on the Right to Information Act, when we scrutinize the result which could not be published, we see that the eligible candidate's result could not be published, and the written examination which was subsequently held, the eligible candidate has been left out. Now, Lordship, a writ petition was in the meantime, a writ petition was moved before the Honorable Single Judge. And in the writ petition, we filed a report, the entire report of the scenario. Now, Lordship, the report is within this, original report is filed within the record of the Honorable Single Judge. This is the record. This is the, kindly see this report.
No, your application is only for extension of interim order, extension of time, that's all.
Extension of time, but
Then
kindly
why-
consider this report.
Then why?
Now, Lordship, the subsequently scenario has been changed.
Then have you taken out any application for further order?
Now, we have filed an application for extension of time.
That's all.
Yes, but Lordship, now we are in difficulty because in publishing the result, we have seen something.
This is up to you, because as I find from the earlier order, that the writ petition was filed alleging inaction on the part of the sub-commission in publishing the result of the written test. The report was called for, and it was opined by the commission that the written test of such and such is yet to be published, and the reason for non-publication was shown as lack of instruction from the education, the Minority Affairs and Madrasa Education Department. The single bench directed that the respondent number 1 appeared in the said examination and on such and such and not on such and such date, as you said, and directed the commission to immediately intimate the writ petition the result of the evaluation of the answer script, and if it is found qualified and eligible, to be published.
Lordship,
Single bench says that within 14 days, everything is to be done.
we have taken steps.
We extended it to 6 months.
6
What
months.
more?
Now-
Can we go into in more details?
Now situation has been changed. Lordship, kindly consider the affidavit which have been filed before the Honorable Single Judge.
Sir, our jurisdiction is very limited. Our jurisdiction, we lost session of the matter the moment we dispose of the matter. Now, question was that we extended, instead of 14 days, we extended it to 6 months.
Lordship, now we have, Lordship, started to
Now-
publish the result.
Now, you said that you could not complete within 6 months.
Yes.
The only thing we will consider whether there was a genuine efforts made by you
Yes.
in terms of the order of the single bench, or
As per the order of the Honorable Division.
not, we simply extended it. Or there has been some kind of a, the dereliction, discharge of your duty at your behest.
Yes, kindly come paragraph.
If you want, we can extend, they are here, we can
No.
extend a further time.
Now, Lordship,
period of 1 month
what,
or a 2 months, not more than that. We will not enter into any other arena.
Lordship, kindly come page 7, paragraph I.
Cannot do. We can
Lordship,
simply
kindly,
extend.
Lordship, kindly come paragraph I. What are the difficulties in publishing the result we are facing? Kindly come paragraph I of this affidavit.
What we will do? You have not made out any case like
Lordship,
that.
this is Lordship, our prayer is let this examination, written examination be held, including all candidates, more or less 94,000 candidates now. We have to, Lordship, allowed to take seat in the written examination. This is the situation, because if we republish the result, at least 50,000 candidates are left out. They are eligible. So, Lordship, it has been pleaded in paragraph 5.
No, who is eligible and who is not
Lordship,
eligible?
this is,
You conducted the written test
we
examination.
have prepared the list.
Sir, you conducted the written test examination.
No, Lordship, that is the difficulty.
You
We have
conducted, that is
contacted-
appears. Respondent number one sat in the written examination.
Respondent number one sat in the written examination. At least 40, Lordship, the 50,000 candidates are left out.
Sir, then we'll have to do something.
Lordship,
I do not
this is
know.
the liberty I am praying before your Lordship.
What for?
We want to hold the Lordship, the written examination, including the candidates who already appeared before the written examination.
Why they will sit again?
Otherwise, Lordship, the 50,000 eligible candidates, they are left out. They will not be allowed to participate in the written viability test because when they are eligible,
That is now you are saying.
after the scrutiny, it has been revealed. Kindly come page 7, it will be Lordship, it is prepared by the commission. Though the commission, after pronouncement of the judgment of the Honorable Division Bench, dated 4th February,
Maybe subject to what is said, maybe constitute an evaluation committee for that,
Lordship,
headed by an independent person.
Lordship, we have no difficulties. Because this is the situation. Lordship,
Because what you are trying to do is that you wanted to bring 50,000 also within that.
No, 50,000, they appeared in the
You
preliminary examination. First of all, we hold the preliminary examination. They are successful in the preliminary examination. Now, in the written test, Lordship, 94,000 who are eligible to sit in the written test, who have qualified in the preliminary, 50,000 at least candidate has been left out. That is the situation, Lordship, we
Why
are
left
facing.
out? Why it was left out?
Lordship, that is the explanation I have given in the paragraph I.
This show us why it was left out.
Kindly come page 7. Paragraph I. Though the commission, after pronouncement of the judgment of the Honorable Division Bench dated 4th February 2020, started the pending process of the recruitment of Group D in different non-government aided madrasa in West Bengal. During such process of evaluation, several technical errors which are serious in nature have been detected, which required a thorough and de novo evaluation of the entire examination process of Group D post. During the evaluation process, it appears from the prima facie inquiry that although 26,445 candidates are declared qualified in the screening test for Group D, and these 26,445 candidates appeared in the written examination of Group D held on 29th May 2011. But actually, total 1,01,064 candidates are found to have qualified in the screening test for Group D and would have been allowed to appear in the written test of Group D, which has been held in 25 May 2011. Total 74,619 candidates who are eligible to appear in the written test held on 29 May 2011 after qualifying the screening test for the post of Group D had been left out. Now a thorough de novo re-examination of the process of recruitment is required to be done. Due to such process, further time is required, and the Honorable High Court may kindly allow 6 months further time to such process. Due to such situation, the Commission has to take a policy decision whether to conduct a fresh written examination of total 1,01,064 candidates, including 74,619 eligible candidates who had been left out, and those 26,445 candidates who had been already appeared in the written test examination of Group D held on 29th May 2011, or to scrap the whole recruitment process for the post of Group D. The errors which have been detected in the said selection process are of so serious in nature, and it entails a policy decision to be taken for proceeding further. In terms of 5.2 of the West Bengal Madrasa Service Commission 2008, chairman and the members of the commission shall hold the office a term of 4 years, and since this is not, this is the situation. So now
Nothing is disclosed that what is the serious lapses, what is the serious.
now Lordship,
Show you have to. That what is the seriousness? What is the seriousness in this? If you can disclose.
Lordship, in evaluating the OMR seat, what happened? Lordship, the eligible candidates' result has been showed that they are unsuccessful. So
No. How?
this is the OMR seat, Lordship, evaluation of OMR seat through computer.
OMR seat is always taken in an optical magnetic resolution with the software The moment you put into the software automatically generates.
That is the difficulties.
Now the generation is that if they say that these are the person who have correctly done, then in that event, you have to say that there what was a fault, what is there, what you detected, OMR, everything you have to indicate.
Lordship, this is the OMR sheet,
No,
evaluation
this
of
is
the
not-
OMR sheet, Lordship, that is
It is done
particular.
it is done through an artificial intelligence.
Yes,
With the software.
Lordship.
So where is the
The
difficulty?
fault of the, this is the fault of the technical fault.
No.
That due to such fault,
No.
the eligible candidates could not be evaluated.
No. There is a hindsight of it also.
This is the situation, Lordship. Now,
We can't take it as so simple as you wanted to project. There may be a hindsight.
so Lordship, we are trying to hold the, Lordship, the written examination. Lordship,
No,
we are not against this.
we do not
recruitment.
know the person who has been disqualified in a
Disclose
preliminary.
before your Lordship the entire result sheet
No.
of 1,01,074,000.
What was declared at one point of time. You can't reopen it now saying that this is what is there unless you have a very strong evidence in this regard.
Yes, we have
A person who was shown not qualifying in a preliminary test for the for further written test, then there must be a result which was shown that he obtained this much of marks in the preliminary test.
Lordship, we are ready with the results. We can produce the entire result of screening test of 1,01,000 who are eligible, including the candidates who appeared in the written test.
How you came to a conclusion that they are eligible? Not a single candidate who have been left out or who were found. They did not come before the court. They did not allege.
No, we have, Lordship, we have evaluated their, Lordship, the OMR sheet. In the, Lordship, in a certain procedure, it appears from this, Lordship, the procedure that they are eligible candidates.
From where you got it?
Lordship, the deep.
Sir, this is not a manual way you have done it.
Yes.
You have put it into a software. And then you find a different result than the earlier one. Will you not justify that what was there in the earlier?
No, earlier result which has been published.
Sorry,
technical.
you have not done it. You have said that you want to take a decision. We will not enter into those. Whatever decision, what you will.
No,
take,
Lordship,
we
we want to, Lordship,
we can simply extend the time for a further period of 3 months to complete it. This much we can do in this application.
Now,
Not
Lordship,
beyond.
only also I am
Not
paying for liberty to hold the,
No, we will
Lordship,
not.
the written
We will
examination.
not.
Otherwise, Lordship, the eligible candidates are left out. That is, it appears from this report.
We will not.
Lordship, kindly consider paragraph I, because now.
Where is the opposition? Opposition has not been affirmed.
Now, this is filed before the, Lordship, one writ petition was filed before the Honorable Single Judge. In the Honorable Single Judge directed us to file a report. And this is that report.
You go there, why we will?
No, this writ petition has been, this writ petition has been, Lordship.
Which application you have taken out?
Lordship, I have filed an application. Lordship, there is an order of the Honorable Single Judge to agitate this issue before the Honorable Division Bench. Lordship, kindly come
That does not confer a power upon the division bench to go into.
No, Lordship, kindly come to the can number 7.
Where is the Advocate General? We will not enter into. Why we should? Where is your application for extension?
Yes.
Can 7 is your application?
Can 7, Lordship, this is the application of a candidate who filed the writ petition before.
Sir, I am asking you, this can 7 has been disposed of while disposing of the main appeal. I am simply asking you an application taken out after that judgment is delivered by the division bench.
Lordship, I am not praying. I am only praying. I am praying for extension of time.
Sir, where is that application seeking extension of time? Which number?
Lots of the application, it was affirmed on application for modification of the order dated 4th February 2020.
Where is that application?
That is July 2020, it was affirmed.
4431 is your
Yes,
application?
yes, 4431. That was simply extended at the relevant point of time, Lordship, it was this
That's
anomalies
sorry.
could not be detected.
Sorry. He has said that result could not be published because of the lockdown having been declared. That's a very genuine problem. No difficulty. I think they cannot also oppose to this.
Now, Lordship, this is
No
a,
difficulty.
now, Lordship, only
You
one
wanted
thing.
a 6
Lordship,
months more
this,
time.
Lordship, we want to file, then we want to file an affidavit before your Lordships because the affidavit is required. Because your Lordships is extend the time, we cannot, Lordship, publish the result because unless this is clarified that the left out candidate, what will be the fate of the left out candidate? Lordship, this clarification is required. So, Lordship, kindly give me a 1 week, 2 weeks time. I filed an
That is up
affidavit.
to you. That is up to you.
Yes, yes. Lordship, I'm praying for 2 weeks time.
This is what you have not prayed for. You
No, no,
have simply,
at the relevant
simply
point-
filed 2 applications, 4431 and 4433. 4431, you wanted an extension of 6 months' time.
Yes.
And 4433, you wanted that this application should be heard immediately.
That is the relevant point of time. It was the procedure that this application has to be filed.
Correct. So we dispose of both the applications.
Now, Lordship, this, we
And
want to file an
extending the
affidavit
time, there is
because
no difficulty. We can extend the time.
now, Lordship, not only extension will, the Lordship creates.
Nothing has been prayed.
Lordship, we are facing difficulties.
But nothing
We are
has
the
been
recruiting authority. We are facing the difficulties.
Where is the Advocate General?
Lordship, today due to his illness could not come.
Could not. Then we are disposing of this matter.
Now, Lordship, this kindly visual. This is the difficulties we are facing. Lordship, unless and until this clarification is made by this honorable court.
Sir, you have not taken out an application in a disposed of matter. Please consider the scope of interference. We have become functus officio. The scope of an interference is very limited on a parameter of law.
Lordship, this was
The
because this
difficulty
affidavit
is-
we filed. before the-
Difficulty is, if you have, then we'll have to take out.
Lordship,
do
kindly 2
something.
weeks time, I file an application
Not.
or affidavit, Lordship, disclosing that this is the situation and what is the present, Lordship, the policy decision we have taken. Because
is-
policy decision as
Nothing
per,
has been taken. You said that we are contemplating to take a policy decision, whether to scrap the whole of the entire
no, Lordship,
process,
what are the,
or we should go for. This
Obviously-
decision has not been taken.
Lordship, the
We
obviously,
can't say that.
no, obviously commission has subsequently taken a policy decision.
Sir, in the affidavit, you have not said it.
This affidavit filed in August 2020.
This affidavit which you,
Now, this affidavit filed before.
I do not find
Now,
from
this is
this.
subsequent event. Policy which has been taken.
Sir,
This is not on
this
record, but
affidavit must, you have not shown when it is affirmed.
no, this is affirmed affidavit filed before the honorable single
Sir,
judge.
we are not dumb. This writ petition appears to have been filed in 2021.
Yes.
This affidavit must have been filed in 2021 or 2022 or 2023.
2021, this.
Correct. Till 2021, when this affidavit is filed, you have not said anything that any decision has been taken. You say we are thinking what to do.
No, subsequently,
sir,
policy has been
sir.
taken to hold the Lordship, the written examination of the left out
We
candidate,
don't know.
along
We
with
don't
the
know.
candidate who are successful in the present.
There's nothing on record. You are saying
No,
for the
I
first time.
filed an affidavit.
That is up to you. We can't
Yes,
either
kindly,
grant you a leave.
kindly adjourn it for 2 weeks
We
time.
can't grant you a leave, nor we can postpone. This matter has been assigned for this limited purpose. We are going to dispose of. We are extending the time.
No, so kindly, because we cannot publish the result. This is the situation we are facing.
You have asked
In-
for 6
before the
months. We are
honorable-
giving you 6 months time.
Now,
That's
before the honorable single judge, we affirmed an affidavit that this is the situation.
Is their problem? আমরা কেন করবো? আমরা কেন করবো? But the single bench to one, single bench to dole change Hello, except for not publishing has been given as well. It's yet to be published instruction. Assembly minority organ I did not give an instruction to the company. We try to find out the relevant rules. Does not show whether written test has been held. Such instructions are required. Neither do the rules show that the result to be published. However, the effect of result may fluctuation. It is not the case of the invitation that has been sent. According to this disclosure recording to appear in the examination, the as submitted by both the councils and directing the respondent number 2 to forthwith intimate to the result of the evaluation. If he is qualified, then prepare a plan. If he is eligible as qualified candidate, then the said respondent shall issue an invitation for personal.
Also, kindly come consider can number 8 in connection with this mandamus appeal. Can number 8. It appears in the record lordship of the Honorable Division Bench. Yes, lordship, kindly come turn page 50. That is the writ petition which have filed page 50. Osman Ali Shah and another. This is the writ petition on record. In this writ petition, lordship, the order was passed to file an affidavit. Now, lordship, kindly come page 62.
This application is taken out by by whom?
By one of the candidate who filed the writ petition.
Correct. He wanted that there should be an order commanding the respondent to forthwith publish the result.
Yes, kindly come page 62.
There is
This
no page
affidavit-
62. You're talking about can 8. Can 8 is taken out by one Osman Ali Shah
Lordship, kindly. So I'm sorry, lordship, kindly come
and
can
Ibrahim
7.
Mandal. Ibrahim
seven.
Mandal
Lordship,
for
kindly can 7.
commanding the respondent to publish the result of the first level
Kindly
case.
come can 7 because I have been served with the application where our report has been
Seven
annexed.
bolo. Yes.
Kindly come page 62.
This is an application for addition of party
Kindly come page 62.
at the behest of the applicants
Yes, Osman Ali Shah.
Usman Ali
Filed the writ petition.
and Ibrahim Mandal.
Yes, kindly come.
Now, what is the prayer which is made in this application?
The kindly come page 62.
What is the prayer? Impleading the applicants as party respondents in can.
Yes, kindly come page 62, lordship, because this affidavit is on record.
What?
Page 62, kindly come page 62. Page 62 of this application.
No. They wanted to be added as a party in
Yes.
your application 4431.
No, lordship, this affidavit, lordship,
They
my
wanted.
contention is this affidavit has been taken into
Let that
consideration by the Honorable Single Judge. The Honorable Single Judge has pleased to direct to agitate all these issues before the Honorable Division.
No.
This is the order. Lordship, kindly come page 62 and the order which was passed in the Honorable Single Judge. Yes, obviously. No.
Page 62 of what?
Page 62 of the can 7.
Yes. What is this?
This is the affidavit which I have, lordship, the
affidavit of the respondent number 224.
yes, that is we. That is a
So-
commission.
so-
Now, our on the basis of our affidavit, lordship, the Honorable Single Judge directed the petitioner to agitate all these issues before the Honorable Division.
Where is that order?
Lordship, this is the order of the Honorable Justice.
Where is the order? Not
Sinha.
Honorable Justice. Where is the order? You have wrongly submitted, sir.
No, lordship, this is the issue.
Sorry.
This is the admitted fact.
Sorry, it is submitted by the parties that the issue in question, I do not know what was the issue in question, is pending consideration by way of an application before the Honorable Division Bench in
Yes.
Committee 907.
Yes,
This is, we do not know what issue.
this is,
You have
this
the-
writ petition.
Now, question is, there is no issue which is pending. Only issue pending is extension of time.
Extension of time.
That's all. We are deciding it.
Now, Lordship, kindly, page 68, this is the order. Page 68.
I'm looking at page 128.
Now, kindly come page 68.
What 68?
This was the order passed in Osman Ali Shah. Now, Lordship, on this writ petition, now this writ petition, we filed an affidavit.
What is this? There is nothing. Simply recorded that he filed, seeks time to file an affidavit to bring on record, Advocate General said, and delay, which contributed to a delay in publishing the result. It is submitted on the date on which the order was passed by the division bench. The commissioner did not have a relevant particulars, hence has sought time to publish the result.
Yes,
now-
kindly come over now page 62. After that, we filed this affidavit before this honorable single judge.
But we do not find that after that Justice Sinha simply said that this is the issue involved is pending before the division bench. I do not know what issue. In the same matter. Same matter at page 128.
Yes, page 128. So,
Same matter.
now, Lordship, now this affidavit has been taken into consideration by the honorable single judge.
Let him.
Yes, now, Lordship, we have through affidavit, we have disclosed it that this is the situation we are facing because a large number of eligible candidates are left out. Now, your Lordship is pleased to direct us to publish the result. Yes, we will publish the result along with to taking up the Lordship the written test of all candidates.
Till date, you have not disclosed what is the problem. Why they were left out, what is the difficulty, what you perceived, what you found. Till date, we are in dark.
So
Nothing has been disclosed by.
No, Lordship, so far the candidates are concerned,
You simply
26,000.
said that you found 1 lakh something candidate was found eligible, but they were not allowed to sit in the written examination. How, when, where, in what manner, nothing.
So that
Will you not disclose that what illegality has been committed by the then committee or the
No, this
office
is
bearers
also
of
the
commission?
technical fault because the OMR seat has been evaluated
We
by
do not know. We do not know. You'll have to say that it is the same OMR seat which was there, is the same OMR seat which is now, which you
same
have input.
OMR seat, same, everything same.
We do not know. Nothing has come out.
Lordship,
What was the technical fault? The system which was provided by an outsourcing agency,
yes.
outsource agency, whether he has declared the system to be faulty, nothing. We don't know anything. Everything we are
Lordship,
presuming.
everything we
assuming.
will disclose. Lordship, that is not that we will not disclose.
Sorry, we have not come across.
Now,
Till-
now everything will kindly give me a 2 weeks time. Everything will disclose because if your Lordships,
Nothing on the record. We will not go by
Lordship, this is
what he says at the bar. What has been pleaded in the application will go by.
Lordship, this is we are facing the trouble. What trouble we are facing? Because if your Lordship direct us to publish the result even without a 6 months, Lordship, we have to hold the written examination of all candidates. Because now we will face problem because they are eligible candidates who are left out. They are not allowed to participate in the written examination. This is the situation. Lordship, we obviously will consider the candidature of the candidate who has submitted their application. We will not, Lordship, they allowed any fresh candidate. Among the candidate who has submitted their application, their candidature will be only, Lordship, considered. This is the situation. 74,000 eligible candidates. We are facing trouble because they are being eligible, unable to participate in the written examination.
That's all.
Lordship, let me sometimes to disclose all these things because every data, Lordship, we have.
I am asking you on a proposition of law. A matter has already been disposed of.
Yes.
The court becomes functus officio. How far the court can go into those
Lordship,
aspects?
we are not saying that.
Under what law the court can?
Lordship, may I? Lordship,
I'm asking you this. All the points, I do not know what is there. Your application is very simple to the extent that you wanted an extension of time, to which they have also agreed that the time should be extended. We are extending the time. What remains?
Extending the time with the liberty to hold the written examination afresh, along with the all
Sir,
candidates.
show me the law that the court can reopen the whole of the issues.
But the
The
situation.
court can rehear the entire matter. The court can do all sort of things as if the entire matter is writ at large. The court can do it
This is not
after
that-
the court finally delivered a judgment.
No, this is not that.
Disposed of the appeal.
Lordship, we are not, Lordship, praying for, Lordship, recalling of the earlier order. We are praying for the same order be passed. Because some, Lordship, rider is required because, Lordship, this is the situation. Because when we started to publish the result, these anomalies have come to our, Lordship, the picture. Lordship, kindly consider, visualize our, Lordship, predicament, what we are facing the difficulties. Lordship, we can publish the result. We can hold the written viability test of the candidate and publish the result. But what will be the fate of the candidate who are left out? And these left outs are genuine because they have eligible in the, Lordship, the screening test. Lordship, kindly give me a 1 week time. Let me file an affidavit, a detailed
I'm
affidavit.
asking you a law on this subject, whether the court can. I'm just asking you this.
Lordship,
We did not interfere with the order of the trial court. The trial court order is very explicit, which says that the rule does not provide for any concurrence from the state government department. The rule 17, which you relied upon, does not say so. 18 and 19, obligation on your part to do it. And the single bench has said that you should immediately intimate the result to the respondent number 1, evaluate, publish it, and take further action. If personality test is required to be done, do it. We did not interfere with the order, but we find that the entire exercise was directed within 14 days,
Yes.
which is absolutely inadequate because of the voluminous applications are there. We extended the time to 6 months. Now you have come up citing that pandemic struck because it was just at the, I would say at the eve of the pandemic, the order was passed and the 6 months period expired during the pandemic. We'll extend the time. There's no difficulty, but we will not go into any other aspect, which we legally show us the law that we can do it legally. We are ready.
So let them.
Under what provision of law, what powers which has been conferred upon us to, which really confers power upon us to do so, we are ready. We have no difficulty. We'll hear you, but we do not find anything from you. And we have to go by the pleadings. We cannot go on the oral submission made at the bar without any corroboration, without any pleading anywhere.
Now, Lordship, this application has been admitted. This application, that is Can 8.
Sir, this matter is assigned much earlier. This application appears to have been filed in 2021. Till date, nothing has been done by you. When even on 30th of August, when we directed this matter to be listed on 12th, you had a 13 days time with you. You had everything in your pocket. You knew it everywhere. You have not done anything.
So far the
You
disclosure
did not
is
do
concerned.
anything. Now what to do?
No,
Are you a privileged litigant?
Lordship, so
No.
we have disclosed. This is
Sir,
the.
you are not
candidate.
disclosed here. We are concerned with the instant appeal. That has not been disclosed. Will
Lordship,
not.
kindly give me a 1 week time.
What for?
Because this
What for? It's merely this matter would be shown pending.
No, Lordship, we
Nothing
disclose
more than
the
that.
result. Lordship,
No.
at least we disclose the result. What will be the fate of this? Because
We do not
otherwise,
know. You have not disclosed. We are extending time to publish the result. Then whatever you want to do,
So unless the written examination is hold, we cannot.
you have already conducted the written examination that
We
you
have
have not denied.
But so this is the situation. But so preliminary examination held, written examination could not be held of 74,000 candidates.
Sir, we don't know anything. This is nothing on record.
No, this is
This is
on
nothing
record.
on record. From this can 8, can 9, we do not find.
No, can 8, it has been, Lordship, the pleaded. Paragraph 5,
Where?
page 62.
Yes. The can 8 does not have a page 62.
No, can 7, Lordship, kindly come.
Can 8, can 7 is their application.
Their application,
That's all. We-
they have annexed our affidavit.
Correct. Are you pressing this application or not pressing this application?
I'm not
Pressing this.
Then they have no right.
No difficulty. We will say publish the result. We'll say publish the result. They are not pressing this.
Now, Lordship, this is the, now that they are not pressing the application, then kindly grant me liberty to file a report, this
Why?
report,
Why?
this report which is required to dispose
Page
of this
62, we will say to nothing.
Now, Lordship,
The matter-
kindly,
Matter
Lordship,
to be
kindly, Lordship,
decided
kindly,
somewhere else,
because
we are not going.
now they are, when they are not pressing this application, because they are at the time, relevant point of time before the honorable single judge, they have pressed this, that this affidavit is required. We have filed the affidavit. Now they are not pressing. Then, Lordship, this application was filed in August 2020. So, Lordship, kindly,
Not
there is
August
change of
2020.
circumstances.
Nothing.
There are so many change. Lordship, kindly allow me to file an affidavit.
Sir, you were the appellant or they were the appellant?
We are the appellant.
So what you are supposed to do or what they are supposed to do?
No, we are supposed to
So-
file an affidavit.
Sorry,
So we will file affidavit.
since date, I think till date you have not.
No,
You
we-
had an
Lordship, kindly
opportunity
appreciate.
from
We had
2021.
filed affidavit. We
From
had filed affidavit.
24th December 2021, you took out an application.
Yes.
Till date, you have not done.
No, but subsequently, in terms of the order of the honorable single judge, we filed an affidavit. Now they are saying this is not press. So my affidavit is redundant. Lordship, let us file affidavit.
They are saying it, what's redundant? Nothing redundant. They simply wanted to be impleted as an applicant in this proceeding.
Lordship, in this application,
This-
they
this
have
proceeding
annexed
they
our
wanted-
affidavit.
They wanted, now they say, I do not want any implement.
They have,
Nothing more than that.
Lordship, kindly visualize.
They do not want.
They have annexed our affidavit, which affidavit I have filed before the honorable single judge. Kindly consider, I have filed an affidavit before the honorable single judge.
Sure.
And Lordship, in terms of the order of the honorable single judge, they have filed this application. Lordship, kindly give me a 1 week time so that I can.
This is
file
an
this
application,
affidavit.
these are the applications taken out by the appellant as well as a non-party to the instant appeal. Seeking a modification of a order dated. Modification of a final order dated 4th February 2020. And implement as a party in the proceeding, in the applications filed in connection with the instant appeal after the disposal, after the said final order. The instant appeal was filed assailing an order of the single bench. Dated 23rd July 2018. Wherein a plea was taken, where the writ petition was filed by the respondent herein, seeking mandamus commanding the appellant to publish the result of the recruitment examination concerning Group D. The first paragraph of the said order reveals that the single bench directed the learned advocate representing the commission to submit a report, which in fact was done on the said date. In the said report, it was indicated that the result of the written examination of first SLST within bracket capital NT bracket close Group D is yet to be published, as the instruction has been sought by the Commission from the Minority Affairs and Madrasa Education Department, Government of West Bengal. And till date, no such instruction has been given to the Commission. The single bench, after considering the relevant rules applicable in this regard, categorically held that the Rule 17 as relied upon by the Commission does not show that where the written test has been held, such instructions are required. Ultimately, the single bench was of the view that since the considerable progress has already been made in the recruitment of Group D, the entire exercise is required to be completed, and directed the Commission to complete the entire exercise within 14 days from the date of the communication of this order. The Commission filed the instant appeal, and the said appeal was disposed of, declining to interfere with the order of the single bench on merit, but held that the time indicated in the said order by the single bench for completion of the entire exercise is too scanty, and therefore the division bench modified the order to the extent that instead of 14 days, the Commission shall comply the said directions within 6 months from the said date. The said order was the order of the division bench dated 4/2/2020 is a final order disposing of the mandamus appeal as well as the applications pending pending therein, and therefore the court lost session of the matter and thus become functus officio. Subsequently, an application for extension of time is taken out by the appellant, stating that immediately after the passing of the said order, there was a complete lockdown declared by the government because of the pandemic having struck globally, which impedes the progress in relation to the compliance of the order of the single bench, and therefore the time may be extended. There is no dispute to the fact that while disposing of the instant appeal on 4/2/2020, this court directed the compliance of an order / direction passed by the single bench to be completed within 6 months. And from the month of March 2020, there was a complete disruption in the normal functioning of the court, as well as the normal functioning in the life of every individuals because of the pandemic, which continued for a considerable period of time. After the resumption of normalcy into the functioning, it is expected that the authorities would also show alacrity in compliance of the directions passed therein. And the moment they have taken out an application for extension of time to complete the entire exercise, taking shelter under the pandemic, we do not find any impediment in extending the time, bearing in mind the disruptions created by the pandemic. At the time of hearing of the instant applications, several other issues are raised by the appellant, impinging upon the merit of the order of the single bench, as well as the appellate court. So it is submitted that subsequently certain illegalities and irregularities have been detected, and therefore the court should reopen the entire issue. But till date, no application has been taken out. And the only applications which are pending before us is the extension of the time to complete the exercise and an application seeking an implement as party. Stop. So far as the implement of the present applicants are concerned, the appeal had already been disposed of, and the application for extension of time having filed by the appellant are pending, which we, in our opinions, does not confers any right into the applicants to be implemented in the aforesaid application, and therefore can 7 of such and such is hereby dismissed. Stop. Can 8 and 9 filed by the appellant is hereby disposed of, extending the time as indicated in the order dated 4th February 2022 by 6 months from date. Nothing more.
So kindly, this is
Nothing more.
my satisfaction, Lordship. Kindly record.
I tell you, the moment you invite us to record, we will record some more observation which may create a lot of problems.
My lord,
We have simply disposed of this application, extending the time,
Aadhaar-
not indicating nothing.
Lordship, some liberty to
Nothing. We
Lordship
can't.
take
Yes.
measures.
What other appeals?
Aadhaar's application for addition.
Lordship.
Where the honorable court passed an order in terms of the order of the honorable division.
That is not
Lordship,
here.
only
My
one.
lord, kindly dispose, nothing else.
Lordship, only one. Lordship, only one
Only
prayer.
Scan 7 is here. We don't know what are the other
For
applications.
addition of
Lordship-
parties.
Where are they? They are not listed.
Yes, my lord. All are listed, my lord.
Hey, addition.
Which are
Can
those?
6, 5, 6,
Mine is can
5, 6,
All-
13, 17, all for.
They are not
Give
able
those
to-
addition of
Yes,
parties.
Lordship, only, Lordship,
Please give those addition of parties.
Lordship, only last prayer.
Some addition of
Lordship, this
parties.
is the last prayer, Lordship. Kindly direct us to publish the result upon taking all measures in accordance with law. Kindly this observation.
This is already there.
Lordship, kindly.
It's already there in the single bench. Why you want?
Lordship, kindly
No,
taking
this is
all
already there.
possible measures.
This is already there. ঠিক আছে?
Good.
হ্যাঁ, সব কটা যেটা একটা রিজেক্ট করেছি ওই গ্রাউন্ডে বাকি সবগুলো রিজেক্ট হবে।
Great.
Who is for the state?
Mr. Ghosh, Sudeep Ghosh. He was here, Malad. He's just outside. He'll just be coming. Malad, the only issue here is, Malad, out of the
Where is
four
the paper book?
out of the four appellates, Malad,
এরকম paper book. আচ্ছা।
I beg to appear on behalf of the victim, my lord, information. I beg to appear in the appeal.
Why you beg? You have a right to represent a
At least, my lord,
victim, then why you beg?
since I have not made part of
Why
this
these
appeal,
kind of a colonial expressions which
I
are
have not
used?
made
Why?
part of the proceedings, my lord.
No, I'm on that. Why you use the word I beg to appear?
beg to appear, Kedah.
Why you say? Why you beg? You have a right to represent. That's a statutory right. It's a constitutional right. You can do it. So why don't use these expressions?
Malad, if a lordship comes to the first page of the paper book.
FIR.
No, I'll come to the FIR. Just the paper book,
First page is FIR.
No, that's page number 1. The first page, other than that.
Yes.
This one. The covering page, Malad, first
Yes,
page.
yes.
Malad, see, there are 3 appeals.
Yes.
Right, Malad? I am in the first one.
First.
Yes.
What about
402?
number 2?
Nobody is here. That's what I'm trying to impress upon your lordships.
But somebody has to be appointed for him.
That's what I'm saying, Malad. Unless we do that, Malad, it won't be.
And what about 3?
3 also, Malad, I wouldn't know who's there. 1 is a jail appeal. From the jail it comes.
No, it may be that sometimes from the jail he has filed an appeal and letter.
Correct. Malad.
I can
Lordship, right.
understand.
Right. So, Malad, this is the question, Malad, which I'm a
But
little-
it is a different person.
Yes, 3. Malad, 4 persons were convicted.
Because you are also in jail. It appears.
No, I'm in jail.
Yes. So it's from the jail. What about the others? Can we segregate? We can't segregate it.
That's on one judgment. It is one judgment, Malad. Only assignment is 1.
Baki? Then what about the?
It should be
But
hard.
only one appeal has been assigned to us.
Yes. Because,
What about, is there any lawyer representing?
Malad, I am aware of in 85,
Yes.
Mr. Sorjati Dotto is there.
Whether this appeal is
Ready
appearing
for hearing.
anywhere. This appeal is appearing anywhere.
No, not anywhere.
No, it is not listed.
It is not listed in any bench.
Okay.
If your lordship so desires, if they have no objections, my lord, I can appear for all 3 of them. 4 of them.
Who has no objection?
Lordship to appear on their behalf. Because I do
No,
not
no,
know
no.
the clients, my lord. They are in jail. I have not been able to get a from them. So, my lord, if the register,
But now, unless these 2 appeals are also assigned, can we?
here it's singly, say to my lord, will say. I don't think so.
That will create a difficulty.
Khali 402
Other 2 also will not required to.
requires to be assigned, my lord. And my lord, if it got be sent to the Chief Justice.
And this is against a common judgment.
Yes, common judge.
There is some noting, I do not know whether this matter was taken up by some other bench. It appears
My lord,
that
my lord, the
special petition was filed.
Suspension of sentence was taken.
but suspension of sentence 389.
There was a special petition as it appears. Any special petition?
Yes, Supreme Court, we moved. Again, the order passed by the then Chief Justice, Justice Radhakrishnan. Chief Justice.
Because I find from the noting.
Yes, yes, well. Notices are there, my lord.
देखो,
Nah,
the
eh,
instant
beta.
appeal being CRA 402 of 2019 is assigned to us. by the Honorable Chief Justice. Along with the applications filed in connection therewith for disposal. In today, when the matter is listed, it has been brought to our notice that against the self-same judgment, two other accused have also filed criminal appeal number 659 of 2019 and criminal appeal number 85 of 2021, which are reported to have been pending before this court. There is no assignment of the aforesaid appeals before us, and this court feels difficulty in proceeding with the hearing of the instant appeal in segregation thereof.
Conflict of judgment.
In view of, in order to avoid any conflicting decisions, it would be appropriate that the aforesaid appeals are heard and decided by a common bench. Accordingly, let this matter be placed before the Honorable Chief Justice for taking an appropriate decisions in this regard. The
Liberty to mention, my lord, after it is.
liberty to mention.
So your lordship not giving any other date now.
Difficulty, Mr. Mukherjee, is another because I am going to hold a circuit bench at Andaman
Oh,
after this week.
Oh, then.
So there is only 3 days left.
No,
Not
no,
possible.
no, my lord, if we get the assignment, we'll mention it that it has been assigned after your lordship comes back. Grateful, my lord.
Call the next.
Item number 10, my lord, I'm for the appellant, my lord, this matter. I'm led by Mr. Mukherjee, my lord. He is appearing, my lord.
Who?
Mr. Mukherjee, Mr.
I beg to appear on behalf of the appellant, my lord. On the other occasion, your lordship was hearing
We are for the appellant, my lord.
the respondents, and at their instance, the matter was adjourned. Yesterday, we have been served with another application by one of the respondents alleging fraud.
Yes, now we do not find him. Mr.
Order number 1 and
Kamalesh
1, 2, 3.
Bhattacharya, 1, 2.
Yes.
He was appearing for 4.
He was appearing for Roman. He was for
Is
Roman.
appearing. I do not know respondent number 4.
Yes,
1 to 3 is represented and 5 is also represented.
he's for 4.
Only 4. What is the matter about?
That Milord horoscope was not Milord probated.
Oh, it's a probate appeal.
Matter.
Holograph.
Not all pages signed with the legislature.
Holograph, typed, executed, not executed, registered, not registered, immaterial. After all, for every kind of a will, you need a probate, at least for this area.
There is a difference in weight between the hologram will and other wills. That's what you have lordships have let down.
Yes.
The respondents are making the submissions.
Yes. Oh, you are appearing. Then it's fine. Yes, then it's fine. Yes, who was making submission?
The respondents,
Yes, please.
they had taken adjournment.
Yes. You have completed your submission.
My lord, I have broadly indicated my points, my lord. If your lordship want, my lord, I can repeat them
Can
today.
you recapitulate?
Very well. I tell you, lordship, at page 38,
Now, let me recapitulate. It appears that the father during his lifetime executed 4 consecutive wills.
yes, all of them holographs.
Those are appearing in page 154 to 174 of the paper book.
Absolutely correct.
These are all the will is executed on the same day, that is 30th of January 2010.
Grateful lordship.
Now the probate has been taken out.
With professional attesting witness. With professional attesting witnesses, advocates.
I was coming later on.
Very well.
So the probate has been taken out.
Rejected. Rejected.
No, probate application is taken out by one of the son.
My client.
Your clients.
Yes.
It appears that 2 of them did not apply for probate as of now. 2 of the sons.
3 of them. 4 brothers altogether. 1 has applied, 2 has not. Your lordship is perfectly right.
In your will also, in all the wills, there is a legal professional who is one of the attesting witness. In all such wills.
Yes.
And in one of the will, one of the brother is also a attesting witness.
That is my client. In the will of Roman.
Correct. Roman is number 4.
Yes.
And thereafter, this is all a holograph will.
All of them.
All of them. Now, whether it was converted into a contentious cause or it was not converted into a contentious.
On account of my fraud, my forgery of the signature of Roman and uncontested probate proceeding was converted into contentious proceeding.
Was it converted into a contentious cause or not?
Because they say because I committed a forgery, I forged the signature of Roman, filed it before the delegate, and then it became contentious, transferred to Bardhaman. I thought it was for the benefit. No fool will convert a uncontested proceeding in which the probate is likely to update in a smooth, seamless manner. I convert it into contentious, goes to the district, there I lose. I have come up to a lordship. Forgery is to that effect. I convert a uncontested probate proceeding into contentious. And before the district judge, there was a fresh service. So the possessor.
You were the applicant before the trial court.
Yes.
So the contentious matter would be when the others object to it.
I forged their signature and made it contentious.
Who said that you forced the signature?
Roman.
Roman, whether he filed any caveat, whether he filed any affidavit, whether
Filed a caveat to a learned advocate in Asansol court. They now say he filed a caveat in Asansol court, delegates court, to a learned advocate. No allegation. No allegation against the advocate.
There was no caveat, filed a vokalatnama.
Then it became contentious.
And now they are saying that vokalatnama was not signed by them.
No allegation in the advocate who appeared.
On the advocate.
Let us hear him.
Oh, ছেড়ে দাও বাবা তুমি এদিকে এসো এদিকে এসো
Mr. Banerjee is here.
For whom?
For
Mr. Haradun Banerjee has arrived. তোমার নাম শুনেই যেন শুয়ে পড়ি।
Mr. Mukherjee appears to be undeterred with this.
I saw him, my lord, go back in his chair, my lord, almost like going to sleep.
As it appears, he was too calm and relaxed by pushing the reclined chair.
Rocking chair.
Reclined chair.
That's a rocking chair, not a
It's
recliner.
not rocking.
It's a rocking chair. My lord has forgotten, this chair has been there since for ages.
Rocking. At that time, reclining
Was not there.
concept was not there. Yes. Yes.
Lord, I have seen the record. I have seen the record.
That's very
Also-
good because we will be benefited by that.
I have seen the record. Even, my lord, I have inspected the will. I have inspected the will, my lord. Lord, I have also seen, my lord, the Vokalatnama was filed by my client. Now, that Vokal-
admitted file.
No. Let him. Let him, Mr.
I have seen that the Vokalatnama is there
Yes.
on the record. Lord, I have verified also. Lord, rest thing, my lord, I did not say to the court in what way the Vokalatnama was filed. I need not, because I could not prove before your lordship. But it appears from the record that there is a Vokalatnama. But my lord, that Vokalatnama was filed in the suit, not in the case.
Why this?
There is a distinction between a case and a suit. Probate suit and case. Probate case is filed initially before a delegate court, not to the district court, district judges court. District judges court, my lord, is to be filed only when caveat is lodged. Before a
Filing, I think it is sent to the district court because the delegatee court does not have the jurisdiction to decide any contentious cause.
right. And that is why, my lord, they have to file a fresh claim there. Therefore, it was registered as a suit and some other court.
Why
Lord,
fresh
I'm
claim?
telling you, Lord,
Why?
some court-
I have not come across. I just want to learn. I don't know about it because I know the application. Please correct me. I may be wrong. My impression about this proceeding is an application for probate is taken out. And when the power is vested upon the court by virtue of a power of delegation, then it is deemed at the stage of filing that there is no contest. Obviously, when it is accompanied by a affidavit of consent, no difficulty. If it is not, then the general citations or the special citations or whatever is required to be done, that is done. Even thereafter, nobody came and objected to it, then the delegatee court can proceed and decide the probate uncontested, no problem. The moment the caveat or there is some affidavit raising objection as to the grant of the probate is concerned, then definitely that proceeding at that stage is to be sent to a district judge for the purpose of why the separate filing of the claim. I do not
some
know.
court I have seen.
I do not
Yeah, that
know.
is why,
That
my
is
lord, I'm
what
telling-
I may be wrong.
No, your
Subject to
lordship is
both
right.
of you are senior here.
Lord, your lordship is, my lord, right, my lord. Nothing is wrong, my lord. Some court, my lord, are because it is converted to a suit. Practically, that file is to go to the probate suit. We will send to the district judge. It will be registered as a suit.
That
Then
is under
notice
the
is to be issued.
CRO. That is
Then
under
as
the
per CRO.
that is under the CRO.
CRO.
But it is that application which goes.
That application to the court and then.
There's no difficulty.
Now, my lord, here I have seen that the case number of both the cases are not same. When the
Cannot be.
Yeah, that is the reason.
Cannot be, sir. You
Yes,
have
yes.
experience of
No,
the
no, no,
trial
no.
court.
That is why I'm telling your lordship.
Yes.
That is why I'm telling your lordship.
যখনই ট্রান্সফার হয়ে অন্য কোর্টে চলে যায় এটা সেপারেট
Lord, that is why I'm telling in the Vokalatnama, probate suit number is given. Not probate case. Means as if the Lord Vokalatnama was filed in suit.
correct. Which is a page?
Lord,
the
that is
paper
in the lower court
No, no,
record.
they might have annexed here.
No, that's
They're all
এই
flag
রেকর্ডটা দাও তো, লোয়ার কোর্ট রেকর্ডটা দাও।
police filed. Flag mark করা আছে দেখো last date টা দেখো flag mark
কোথায় আছে গো?
records
এই তোমরা এটা তো এক্সিবিট করিয়েছো না? ওকালতনামা নামে এক্সিবিট করাওনি তো?
ওকালতনামা তো part of the record, ওটা তো
ও
evidence এ আসেনি তো।
ওহো, এক্সিবিট করাওনি। পার্ট অফ দি রেকর্ড, তোমার কথাটা মানছি আমি।
করিনি স্যার।
পার্ট অফ দি রেকর্ড আর এক্সিবিট দুটোর মধ্যে তফাৎ আছে। Lord, in the, your lordship kindly look to the Vokalatnama. The mentioning of the suit number, not case number.
Oh, Mr. Banerjee, probably your contention that this Vakalatnama was filed in the suit after the probate was converted into a contentious cause
Because
is not correct.
Because, my lord, the probate suit number is given in the.
No, I'm telling you.
That is
Where,
the reason.
no, probably you have not noticed that. We have a Vakalatnama with us. The Vakalatnama appears to have been filed on 12/11/2014. In 2014, 12th November 2014, when the application for probate was filed before the delegate, which was numbered as will case number 190 of 2014. And this contentious cause, after it is remitted to a chief district judge, that was on 25/2/2016.
Yes.
The first order says, will probate case number 190 of 2014, which was initially filed before the district delegate, Asansol on 6/8/2014 is refiled before this court this day. In respect of a testator such and such, whereform it is subsequently returned to the petitioner for presentation of appropriate forum, it becomes a contentious. I do not know, seen the office report, but this was not, because it contentious cause means it is now registered as a suit after it becomes contentious. So Vakalatnama was filed prior thereto.
Therefore, soon after the Vakalatnama was filed,
Then it becomes contentious.
means it becomes contentious.
Then it becomes contentious.
It becomes contentious.
Because I find the Vakalatnama contains Will 190 of 2014.
Yes. Therefore, it appears from the record, my lord. Another thing I have seen, but I cannot argue on that also. Practically, the return that has been given by the bailiff of the court, Lord, there was no verification affidavit in the summons. All other summons, my lord, affidavit is there by the bailiff. Process
one?
server. Process server.
Yes.
Report of the process server.
Yes.
So far, the defendant number 4 is concerned, there was no verification in terms of order 5 rule 19, my lord. And this is mandatory. In other return, my lord, I have seen verification is there. But in this return, there is no verification.
No, there was a publication which was directed to be done.
No, publication, my lord, your lordship knows the judgment of our honorable court, my lord. Unless a valid service under order 5 rule 19 is given, he cannot go forward to publication. Lordship knows the judgment of Justice Hon'ble said. Their order 9 rule 13 was allowed on that ground because order 5 rule 19 was not followed.
No.
But publication was there.
That is in respect of, if you go to the Limitation Act, where it says, in the Limitation Act, it says that the service under Order 5 Rule 19, this for substitution shall not be regarded as a good service for the purpose of Order 9 Rule 13. That is the another reason. For that purpose, it says that it will not be regarded as a good service. If you come, are you aware of that provision? Limitation Act, you must be aware, we learned. Where is that article? Where is that article of the Limitation Act?
Not in the Limitation Act, there is the article, my lord.
Yes, it says that it will not be regarded as a good service.
Yes, my lord, there is a.
Yes.
In the Limitation Act, my lord, there is that.
Article 123, I am reading.
123.
It says to set aside a decree passed ex parte or to rehear an appeal decreed or heard ex parte. 30 days is the period of limitation provided. The time when the limitation would begin is date of the decree or where summon of the notice was not duly served, when the applicant had a knowledge of the decree.
Therefore,
And then an explanation appended thereto says, for the purpose of this article, means 123 only ex parte, substituted service under Rule 20 of Order 5 of the court shall not be deemed to be a due service.
Shall not be deemed to be a
So it is only in respect of ex parte.
Only in respect of ex parte.
If you want to set aside the ex parte decree.
I am expert. I am expert.
Go for Order 9 Rule 13.
Why should I go, my lord? This is the order has been passed in my favor. Order is in my favor.
So that judgment has to be read in that perspective.
Yes, my lord.
But here I find from the record. This is also written that you did not file Wakalatnama in the suit.
Yes. I did not file any Vokalatnama in that suit. And when it is converted to a suit, my lord, then appearance that everything is to be followed by issuing summons.
It says that the summons were
That
served.
summons will not do, my lord.
The general notice was given on 1/7/2016 and 24/11/2016, respectively. But till date, the WS has not been filed by the OPs. That is an order number 13 dated 29 January 2018, passed therein. It says the court records that OPs are not interested to contest this case. Then say, I also find that none of the OPs has filed any Wakalatnama in this case till today. Means in the suit.
But when the matter was transferred to the probate suit, my lord, here the phase notice is to be issued. There are judgments, my lord. I can satisfy your lordship.
There is no corresponding provision in the Code of Civil Procedure for that.
Yes.
Show me there is no corresponding provision.
And even, my lord, in a case of transferring the suit under order 7 rule 10A.
It's a different. There is a provision
That is why I
noted
am saying
therein.
that
There are. If the court says no notice, I fix a date and then fix a date and then it goes there, then there is no question of further notice. But in that event, you'll have to.
Lord, only one thing, Lord, I wanted to, Lord, look into that, my lord, that after the probate case was converted to a suit.
Because it's a wrong level service. That.
Yeah.
Lord, after the probate case is converted to a suit, no notice need be served.
There was a general citations which was there and
Not only
nobody,
general
the court
citation.
has recorded, their court has recorded the general notice has been given to all the OPs, not once, twice, on 1/7/2016 and 24/11/2016. What the court will do?
It is no more there.
Which one?
Ajkal.
No, today is always there.
Yeah.
So
Newsprint is getting, but there is no circulation.
what circulation?
Of Ajkal. And my lord, kindly see the order dated.
No, nothing.
1st August 2016. SR received being duly served. Can you check it? Can you check it? Who had received? I never know. This is a specific case.
Except general notice. Except general notice.
Yes. Yes.
Except general notice.
Yes.
Yes.
Petitioner is directed to take steps upon general public non-appears. Lord, it's straightway. Lord, we got the notice from appeal court. Lord, we came here. Why should I not appear there? Petitioner files Hajira SR received being duly served except general notice.
My lord, try to look at page 25 once. Jetu. Najire report.
Page 25 is the Naji's report. Jetu. You're muted.
দেখা
জজ সাহেবের কাছে আছে দেখছেন জজ
It's flag marked as well. But to examine. Judge সাহেব করবেন. Can only thing is there. টাকা নিচ্ছ কেন প্রপার্টি থেকে? বাবার প্রপার্টি বাবার প্রপার্টি দিচ্ছ তোমাকে অ্যাফোর্ড করছি কি করে?
ভয়েতে তোমার ভয়েতে কি করবে?
Specific. Not a general. It's a special principle. Individually response. No. The general. Data valuation.
নম্বর বিবাদীকে পাইলে নির্দিষ্ট পাইলে মর্মকাতরতা সকলের সঙ্গে সামনে রসিদ দিয়া সকলের পড়ানো সকলের মানে জয়েনিং এর
ঠিক আছে আর এখানে yes yes Mr. Banerjee,
Lord, your lordship has.
we have seen that. What is your point? What is your point?
If your lordship satisfied, I am nothing to say. Because my argument cannot develop. If
You are for Ramendra,
I am for Ramendra.
so concentrate on Ramendra.
Yes.
It appears that you have received by
Ah.
putting a signature.
What is it?
Ramendra. We are not concerned with the others. We will come
No,
to
no.
the others
Your
when they raise a
lordship-
point.
Your lordship is not
We will
concerned with
definitely
others.
react to that, whatever they say.
That
But
is
now
right,
you are
Lord, your lordship is
Ramendra,
not concerned with
it
others.
appears that there is a signature appended there too.
There
Now-
was also a verification must be there.
Correct. Suppose if there is no verification, let us see.
Then what would be the effect in the eye of law?
Correct. Show us.
That part.
Show us.
Lordship, give
If
me
it is a mere irregularity or it is such a fatal defect which is incurable in nature.
Yes.
Show
This
us.
is the question.
That's the only thing.
This is the
If it
only
is a
question.
curable, it's a mere irregularity, does not affect the rights of the parties, then what is the law? And if it is so mandatory that non-compliance would, shatter whatever has been done, let us see.
Yes, therefore, my lord, if it is irregularity, my lord, that cannot be,
There are two kinds of irregularities.
Yes, yes.
One is not affecting the rights of the parties.
Party.
and the irregularity which affects the rights of the party.
Yes. If
It is of what kind?
irregularities affect the rights of the party.
Suppose verification is not there, the documents are galore, which manifests certain things, whether this non-filing of the verification or whatever.
Will entail fatal.
Tell us, what is the
This
law?
is one aspect, my lord. This is one aspect of the matter. Second aspect, my lord, is that it is practically a codicil.
It is
codicil, like that is own handwriting of the testator. Holographic will.
Codicil.
Holographic will.
That's I can understand. Holograph. It's a holograph will.
Yeah.
Codicil is something
And now, my
different.
lord, now the evidences are there. Evidence of the testator is there. Sorry,
Not testator, can't
not
be.
testator. Sorry,
Can't
sorry.
be. Impossible to cite him as a witness. Impossible. Huh?
Remarkable case. Lord, evidence of the propounder is there.
Correct.
In a state of propounder, Lord, I am uttered, my lord, testator. My lord, I'm sorry to that.
No, no.
I'm sorry to that. My
No,
lord.
no.
Lord, propounder and the executor. Now, Lord, one executor has been
No, no. Propounder
examined.
is an executor. I think the attesting witness.
Attesting witness has been examined.
Correct.
And one attesting witness will be enough. My lord, law is that one attesting witness. I have seen, my lord, I perused the will. From the will, it appeared that there are 4 sons of the testator. Now, Lord, why the testator or why the other sons were excluded? Why the other sons, other than the propounder, beneficiary?
If I correctly remember, AIR 1959
59 Supreme Court
is against you.
Yes. 59 Supreme Court. Thereafter, series of judgment.
Exclusion of the natural heir does not automatically creates a, the
Lord,
suspicious circumstance.
that is, my lord, the Supreme Court held that it creates a suspicion in the mind of the court. Suspicious circumstances are required to be removed by the propounder.
That onus is upon
Lord,
him.
onus is upon the propounder.
True. That's why I say onus is upon him.
That I have seen, my lord, from the evidences with regard to that suspicious circumstances which exist on the face of the will itself. There was no explanation given why they were excluded.
Okay.
Because court will look into an oblique eye. 59 Supreme Court. Court will look into an oblique eye. Always. They have to satisfy. Even if execution is proved. Even if execution is proved, it has to be, Lord, it is the duty on the part of the propounder to satisfy the court that even if there are suspicious circumstances exist,
Yes.
that has to be removed
Yes.
by the propounder.
No difficulty. No difficulty.
Yes. On this only I shall argue.
Argue?
Practically. Lord, for that your lordship will give me at least 15 days time.
What?
15 days time, my lord.
I already told my brother 10 minutes before. I already told my brothers 10 minutes
myself,
before.
Lord, over this.
10 minutes before.
Lord, 3-4 days. 3-4 days before, my lord, this has been given to me.
So long. তার মধ্যে তো সব দেখে নিয়েছো তুমি তো আবার কি সময়
ওটা দেখতে হবে
তুমি তো বলতে সব দেখে
দেখতে হবে
I'm giving you a judgment. I'm with you. AIR 1995 Supreme Court 1852. What do you say? That it is a duty of the propounder not only to prove the bill, but to remove suspicious circumstances. No difficulty. It is an AIR 1995 Supreme Court 1852. I'm giving you that. I always believe in a parent judgment.
185.
1852. Which is still continuing, has not been disturbed. But show us that it requires.
Lord, few judgments I have, of course, I will have to bring those judgments. Lord, in the will, my Lord, there was no explanation why they were excluded. Now, Lord, there was no evidence laid by the propounder.
Yes.
Lord, that itself is a ground for the purpose of refusing to grant a probate.
Can it be?
Because, my Lord, when the will itself did not say this,
Yes.
why they were excluded?
I know the judgments against you. That's why, if you want, I can give you 3-4 judgments.
Yes, my Lord. Yes, my Lord. Lordship, kindly.
But I know, because the moment I start saying those, it will give that main intention more impetus.
No, my Lord.
মানে তুমি সময় চাইছো সেটাই জজ সাহেব বলছে ছোট ছোট করে দেবে ছোট করে দেবে সময় চাই তুমি একদম জজ সাহেবের রেখে দিও না মামলা করো একদম জজ সাহেবের মধ্যে ঢুকো না তুমি মামলা করো
Whatever the judge will say. Lord, Lordship, kindly give me those, my Lord, so that I can, because I can prepare myself.
No, you have prepared yourself, I know.
But I shall have to prepare myself. I told them.
I think none of the members who are present in the court will say that you do not know what judgment is. Nobody will say that you do not know what the judgment is.
Lord, I have not. Lord, still I want to know, my Lord.
Yes?
Still I want to know, my Lord.
No.
Still I want to know. Lord, it is a vast subject, my Lord. Today also I am thinking I do not know anything. Unless, my Lord, I learn from your Lordships.
That goes against you is 2001 volume 9 SCC.
2001 volume 9 SCC.
Page 726.
726.
2004 volume 3 CHN. Page 288.
88.
Do you subscribe Supreme Court Weekly?
ACC online আছে স্যার নামটা
ACC online.
Supreme Court Weekly. This is AIR Supreme Court Weekly 2001.
Supreme Court BT.
2001.
Weekly.
Page 24.
2001.
Yes. Page 24.
নামটা জিজ্ঞেস করো না
Lord, name of the, possibly name ta pabe na. Name ta leke. Lord, name is there, possibly.
Yes.
Name is, party's name is there, possibly, no.
My bad habit of not writing the name of the parties.
That is, I told.
And the bad habit of Mr. Mukherjee also, not even writing something into it, only the citation.
Only the citation. That I know, my Lord, Mr. Mukherjee.
He writes only the citation and he remembers that which one is what.
Yes.
At least I write, the crux. But Mr. Mukherjee does not write even that. Only the citation and one tick, sometimes 2 tick. That shows that what that judgment is.
Lord, these are the 4 judgments.
আমাদের এগেইনস্টে দেখে আসতে
These are the against. Against me. Yes.
Nothing. You argue. I know you wanted an adjournment.
Lord, because I have seen, once I have seen the record, my Lord, I have seen there is nothing only to argue on that. No other argument I can advance.
Have you read the judgment of the court below? Do you subscribe do you subscribe such view? Is this a law? What he has laid down? Only on that. Just I wanted to know. Is it?
জানো ভালো করে ল লেখি 37 পেজে 37 থেকে আরম্ভ বেসিক্যালি 43
বেসিক্যালি কত থেকে করেছে গো?
43 থেকে আরম্ভ 39 টা দেখো
Number 40. Lord, page 43, from onwards, Lord, page 43.
Yes.
43 হচ্ছে most
Sir, page 40 you come. I think the first problem starts from there. And subscribe your view to it. I can read for you. If you want, I can read for you.
No, no, Lord, although there is no contention.
Correct.
Although there is no contention either in the plaint of the petitioner or in the evidence of the said petitioner, Brojendra Mohan Mojumdar, that his father, Nobonidhar Mojumdar, had written and executed the said will in question in presence of any attesting witnesses.
Is it required to be pleaded? Second.
Lord, my respectful submission, my Lord, it is not required to be pleaded.
Now, but
my-
this PWT, please
Yes,
consider
yes,
what
Lordship,
law
Lordship,
he has
Lordship.
laid down.
But
But this
in
PW2,
his evidence has stated that testator Nobonidhar Mojumdar has written the said will in his own handwriting and put his signature in the said will in his presence and in the presence of other witnesses, namely Tapon Kumar Chatterjee and Supriyo Chatterjee.
he is one of the PW2 is one of the attesting witness.
One of the attesting
Correct.
witnesses.
He further stated,
That he put his signature in the will in question in presence of the said Nobonidhar Mojumdar as per his instructions.
correct.
Pertinent to mention here that beside this PW2, the petitioner did not try to prove the execution of the said will in question by examining the aforesaid. Lord, this is, I cannot. I cannot. Lord, from the at the very beginning, I argued before your Lordship. if
One of the attesting witness
one of
can
the
prove
attesting
there is no
witnesses is
difficulty.
examined.
Why the court says other attesting witnesses should also be brought
No, Lord,
to corroborate? I'll see to it.
Lord,
This judgment will see to
Jadar,
it.
my learned friend Mr. Bose is right. In cases where
Uh-huh.
the one
And should I give some
One-
other judgments?
Attesting witness one is sufficient,
But-
but you are withholding two.
Sorry, sorry.
Judgment, my lord, I am not saying myself.
Anyhow, the petitioner also kept mum about the existence of these two persons, namely such and such,
Lord,
claim to
on
have a
these-
attesting
on
witness.
these I
The
shall
will
argue-
will show who are the attesting witness.
Lord,
Then,
The first case, sir. That is the judge.
we will learn many things. Don't worry.
We are every day learning.
Yes.
Lord, on these I shall argue before your Lordship.
Now, would
Yes.
you subscribe 42, the first paragraph?
The first 2 pages of the will in question and remaining 6 other pages are written in different inks.
Have you seen the will with your eyes?
Yes.
Do you find that this finding is correct?
Lord, 2 pages, my Lord, different ink, and other 2 pages, following pages, different ink. That I have seen, my Lord.
Yes.
Blue, my Lord, 2 pages blue, and then black.
If it is in a 2 different ink pens, does it mean that it is in a different handwriting?
No, cannot be. Cannot be.
That is what I say, first line.
It in different ink and appears to be not in same handwriting. Although during examination of attesting witnesses, Wayan Ranjan Mukherjee said will in question has been marked as exhibit 3-4, but mere marking a document is not sufficient to rely on its authenticity and its contents.
Is it required under the will? When every pages are not authenticated by the signature of the tester? Is it mandatory? Is it mandatory?
No.
I think subject to correction, there was under the pre-independence, there was a Wills Act, I believe so. Mr. Mukherjee would correct me.
Lord, there is an excellent discussion about this in Paruk's Succession Act. Your Lordship will find the English law.
And the
Ancient.
was a form which is also given.
Yes.
Subsequently. But so far as those are concerned not applicable to us.
Jitu, I have that Farooq's discussion. If you want me, I can hand it over.
Later on, let them finish.
Yes, my lord, with regard to that part, Lord, possibly my argument would not be on that. If I can satisfy your lordship that there are
He is
suspicious
proposing to argue. Let him argue, my lord, to his heart content. But today he is merely proposing. On some other day, he will really argue.
Yes, yes.
এই তোমার লিখিত কিন্তু তুমি বলে যাবে আর এখানে এসে সব বলবে আর নিজে একটা পুরো পাহাড় তুমি এনজয় করছো তার কথা কিন্তু শোনা না যায় it is the will
Here is the will. Kindly look to the will, my lord. Original.
My lords have seen it.
Sure, sure. কেন না? তো হ্যাঁ, খুব সাবধানে।
Lord, the law is no longer res integra because the section itself says that if one of the attesting witnesses examined, need not be examined by other two witnesses or three witnesses or four witnesses.
And their non-deposition does not invalidate or create any suspicion.
Right, my lord. Only, my lord, exception to this rule is that if one attesting witness's evidence does not satisfy the ingredients in terms of section 68 and 63 of the Succession, 68 of the Evidence Act and 63 of the Succession Act, read with section 3 of the Transfer of Property Act, and some ambiguity is there in the evidence, then other witnesses are required to be examined.
That all depends upon a case.
That all depends upon case to cases.
It don't have.
That all depends upon case to cases. Now, my lord,
If the evidence of the adverse one attesting witness is absolutely, I think, crystal clear, absolutely free from any kind of a pollution, like a water at the Gangotri, then why others are required?
yes, my lord, be that as it may, whether suspicious circumstances exist or not, number one.
Show us that his evidence is absolutely scanty,
that is why, my lord,
insufficient.
Lord,
No difficult.
because the propounder is required to remove the suspicious circumstances exist on the face of the will itself. Because in the will itself, my lord, the name of the other sons have been described.
So what? Who says?
Therefore, my lord, it is a bounden duty. My lord, there are judgments. I can satisfy your lordship. Now, my lord, only one thing I can draw your lordship kind attention. The reasonings may be correct, but if reasonings of the trial judge may be incorrect.
Oh, you said correct. That's why I reacted.
Reasonings of the trial judge may be incorrect.
But the
But if
conclusion is correct.
right, correct.
We can
Then
substitute.
your lordship
No
can
difficulty.
supply.
I
That is
can.
why, my lord, I
Rather-
will
rather we
bend
will-
upon, Lord, that is why I will bend upon that angle only. I will bend upon that angle only. Otherwise, if I can succeed on the basis of that, I can succeed. If I may not succeed, may not succeed. But my role would be only on the basis of that.
Your role is very difficult, sir. I can hear the
Very
other side.
difficult.
You're difficult.
Yes.
It appears that you have received everything. Even after the suit was converted into a contentious cause, till date, nothing has come out. We can't proceed on that basis.
Lord, even if ex parte.
At least you, I do
even
not
if
know the
ex-
others.
no, no,
At least
my
you,
client, even if ex parte, I can satisfy your lordship.
only on the basis of the
Only
available,
on the basis of the-
available documents.
Yes,
That's all.
available documents.
Correct.
Yes.
You have to
Yes.
show us that
Yes.
this is
Have
what
available
the evidence of both the PW1 and PW2 is not appropriate, not complete, does not discharge the initial owners which is cast upon them. Everything you just show us, if we are satisfied, no difficulty. Our mind is still open.
Yes.
No difficulty.
Yes, my lord. This
No
will
difficulty.
have to. This will have to, because, my lord, only one thing, that description of the other names of the sons, my lord, have been given in the will itself.
So how? That's a
That
more,
is
that's a
what
more,
should be
I would say,
That is
the
why-
genuine efforts of the testator, that I have four sons, four sons
Why they
declared.
were excluded.
And then four holographic will executed on the same day,
Where from it has come? It is not on
the
evidence.
same day.
It is not on evidence.
Let us see. Let us see. If it is beyond the evidence, we will not
No,
take into
no,
account.
whole
If it is-
holographic will has come, no evidence.
No, that you are getting an impetus,
No, not impression.
inspiration from him.
No record in the record.
No.
Holographic will
Yes.
have come.
I believe from 156 to 164.
Now it has been brought in
All
the
right.
court.
It is,
No,
it
Lord,
must be there in the trial court.
No. Order 41, Rule 27 application.
Yes. So we are hearing that also.
Hearing that also.
We'll consider
Order
that.
41,
So
Rule
we can take
27.
into account.
Therefore, order 41, Rule
Only thing
27
is-
is allowed. Order 41, Rule 28, 29 have to be followed.
Which one? We'll follow
Order
here and now.
41.
We'll follow here and now.
Therefore, evidence
No,
is to be
let
laid.
us first. First thing is, they have brought this,
That document can be brought in or not.
and the Supreme Court has in a recent judgment also said that Order 41, Rule 27 has to be heard along with the appeal.
No, along with the appeal,
So
no doubt.
it may so happen, we
That
have
doesn't
not
mean-
formed our opinion. We may not require those
Therefore,
documents for
my
the
lord,
purpose
question
of
would be, yes, if
judgment.
your
We
lordship
may
may
not,
not require
but
that
these
document.
facts are here. These
Yes.
facts are here.
Yes,
So one has to consider.
yes.
Yes.
Your lordship will have to consider that. I will also argue before
So
your lordship.
that is what I
whether
say.
it is admissible
They have
evidence or
brought,
not.
they sought to bring the fact that there are four holographic wills simultaneously executed on the same day. Let us see whether those are
No
material,
evidence
not
has been
material.
laid as yet, my lord, today,
Oh,
till
we
today.
will consider whether
Yes,
those are
yes,
required
yes,
or not
yes,
required.
Yes,
This
yes.
fact, we are not going to give a probate of other wills as well. This is not our job. Only thing is whether this fact is so important for the purpose of granting a probate, or it can be ignored in absence thereof. The sufficient evidence are there. There is absolutely no difficulty. Where is the difficulty? We can proceed on that basis. Only bringing to your notice that this is fact they want to bring. No difficulty.
Yes.
So what more? We will not grant time. It was fixed today. Mr. Bhattacharya failed on the other day. Ultimately, just for the sake of, natural justice, may I use that term, being a constitutional court, we can say only for that purpose we fix the date. So you have to argue.
Lord, I have argued.
No,
Lord,
but
in
that's all
part.
they will
I
consider.
have
that.
argued in part.
No, you have to argue.
I have
for
argued in part. Your lordship kindly consider it.
It reminds me of my days over there.
This is a Lord case of this nature, not general cases. This is judgment in rem.
It reminds me of
This is
my
a case
role
of a
there.
Judgment in rem ex parte.
Mr. Banerjee, my role over there.
Yes.
When a judge is adamant in not granting the adjournment,
Yes.
nice way of getting an adjournment.
Yes.
Successor is
Successor is there.
আমি কোথাকার successor?
No. That is what we are not. We are sure about it. So what you have to argue? He has finished his argument. He has finished. Now you argue. We will finish before that, and we will start dictating immediately. Don't worry.
I say, my lord, I have not been served.
Correct. We will see to it. That's the only way.
Only will.
Only point.
No. Had I been there, I could have pointed out many things.
Yes. True.
First of all, my lord, if
Go.
the lord is considering the only will,
Correct.
which is in the subject matter of probate.
We are concerned with the will. That's all.
So, my lord, I am not saying that exclusion of the others is a ground for such a, I am not saying that.
Then
What I am saying, this is one of the ingredient. If suspicious circumstances exist.
coupled with such others.
Coming-
Yes.
coming-
Then
Second,
what is this coupled?
coming to that.
Yes.
Second is the suspicion expressed by the court saying that the two inks are that, that is not also such a ground, the two inks. No. Two inks coupled with that writing are little different. Court has a power on the evidence act to look into it and court form an opinion that this is different. Third, he is a businessman. And is appeared from the will, he is a businessman. Well, kindly see the writing of the will. It is, my lord, a draft of a lawyer. A person who is general businessman having no knowledge of law. He will write it in the manner, yes, this is my property, I am giving it to a ABCD. Can you see the in every step, whereas, this is, my lord, according to my humble, may be a dictation by a lawyer. If it is a dictation, then, my lord, he has not applied his own mind. Apart from that, there is a judgment. Just now I have tried to find out. Absolutely correct that one attesting witness is sufficient. But if the other witnesses are available, and you have not said they are not available, if you are not bringing him, that is one of the ingredient. Again, I say one of the ingredient to lead to a suspicious circumstance. So if this all are clubbed together, the suspicion is yellow. And which
No
is
difficulty.
displayed.
So those are the points.
Those are the points I have to canvas. One, I have
Nothing. You just give a citation. No difficulty. No difficulty.
I have to right of cross-examination to the witness is also there.
Correct.
I have lose my chance.
Correct.
I have lose my chance. That's required. So because the attesting witness and the other witness is the person who proved the will. So if I am depriving of cross-examining those witnesses, my right goes.
Yes.
One affidavit I can file before your lordship to only to indicate that I was never served.
It's not necessary to file an affidavit. Why?
Record on the fact that
What?
I am not on,
Nothing.
not been served.
You have to concentrate on a ex parte one. You have to show from the record that it has not been served.
It has not been served.
You will take into account your
If the Najib report is there, that I have a right to cross-examine the Najib. And if I am not giving any authority to Mr. Banerjee's client to receive the document, if he says I am receiving for the all, then my right goes. So I am losing my right of cross-examination. I am losing my right to contest a contentious proceeding. These are all factors apart from the point what I can say before the court if I am getting the opportunity or not.
True.
So these are the points is required some details argument.
You have done it.
No, I'm
You
making
have
my
done it.
ready. I will
You have
only
done it.
yesterday.
And not only that, my lord, the affidavit in opposition in the order 31 rule 27, there was no direction given for filing affidavit in opposition as against the additional evidence, proposed
Oh,
additional
this
evidence.
one also you have looked into.
Allow me to
Yes,
file
Lord.
that to record
That
I have not
direction
been
may be
served.
given so that we can file affidavit in opposition
Hey,
also.
High Court
Reply if they want to.
order sheet টা দাও না না ওটা নিও না ফেরত দাও তুমি নিয়েছো কেন
No, I want to file it.
let us see whether we'll grant you a leave to file or not. Thank you.
এই রিপোর্ট তো ওর কাছে ছিল ও যে যে রিপোর্ট করছে ও রিসিভ করেছে he has suppressed those documents in the draft now he is adding it additional evidence দিকে আছে ঢুকে দিল ওই তো বেনিফিশিয়ারি অফ দোজ ডিড অফ গিফটস ওর ফেভারই তো ডিড অফ গিফট করা হচ্ছে he has received the benefit it was within his custody he did not use the draft.
So that is why that document is to be, whether that can be admitted or not, it's a very pertinent question. I shall argue on that also.
এই অ্যাপ্লিকেশনটা কোথায় আছে? CAN 5913 of 2019.
দেখছি দাঁড়াও।
এখন তো রেভোকেশন আমাদের বিল দেয়নি ভাই, আমরা বিল নিতে হয়েছে।
5913 যেটা এখন CAN 3 হয়েছে।
সময় দেবে না না আচ্ছা
না না পেপার বুক এই তো কোথায় তৈরি কি হচ্ছে পেপার বুক? আরে এই কেসে কোভিড হবে না রে ভাই, কোভিড হবে না। আছে না হ্যাঁ
You are representing whom?
Five.
You are for
I am for
Four.
four.
And what about 1, 2, 3?
What sisters? Sisters. That one, it's from their custody that they will.
So they are supporting you.
Yes, I don't know whether they are supporting me or not. Very well, no?
Yes.
There is an affidavit to that effect.
No, one is supporting, it's no doubt.
Writing
Respondent
here.
number 1 is supporting.
I think here, 1 to 3.
All
Nothing before the code below. These pieces. See one, see that should be all. Nothing before the code below. All are here. It's a Vasusland file and provider that's pending. One of the things.
Only.
Huh? 6. One of the plus. This one number 6. One of the.
So I asked,
See
then
the file.
somebody says, no, it's not there. Anyhow.
No notice, I don't know. Now I come to learn there is a property in my favor.
So everything is finished? No difficulty?
Site
And yes, you just give a citation tomorrow. Give all the citations.
Give me 1 week time.
No, tomorrow.
Weekend.
এই
The weekend.
ফেরত রাখো সাবধানে আর বিলটাও একটু বব ফেরত করে দিয়েছো তো স্টিচ করে দাও।
Should I file this? Should I file this?
Which one?
That you are never served on us.
No, that we will take from the record.
The record says served.
We will record your submission that you say that it is never served and whether
Better to have a document in record.
those can be taken into account in an appeal of such nature.
Which one?
Yep.
Order 47. Bow down. My non-service.
Yes, let us see. We'll have to consider.
My lord will consider everything I know. My lord is talking about the order 27 or
No, I'm talking about your submission.
my submission, so that I have been not served.
Not served.
Not relevant.
Not. No. We have to consider that. We'll consider. Cited, not necessary. Cite a judgment. Give a judgment.
Give me 1 week time.
No,
Weekend, can you give us weekend?
tomorrow, tomorrow.
Tomorrow is,
Yes.
though I cannot say that any single judge
Yes.
matter is going on, I cannot say with the division bench. There, well, I have to address it, hearing what is going on. But somehow I manage 1 day.
I tell you why you will find that I am stubborn.
That was-
Because on our last occasion, I think from 2 occasions, this matter was being taken up and there was some kind of a adjournments we readily granted. Even on last occasion, Mr. Bhattacharya was of the very, very firm view that, and he said that yesterday, one of the senior who was engaged refused or declined to appear in the matter. For that reason, we gave him an opportunity because since last 3 days, we are unable to proceed with the matter.
That was the first day it was taken up. It was not.
We
taken up on
remember earlier also, it was because the order sheet says we could not open up. We could not because the adjournment was done. We wanted it to be finished today, and that was the indication given by us on that day when we recorded this order. No, this is an embarrassing situation, both for the court and I think for the bar as well. It's really an embarrassment. The court is being taken for a ride whenever the counsels would come and argue. If they say half-hearted argument, half-baked argument, the bench has to succumb to it. This cannot be done. And we were very firm on that. Otherwise, we were adjourning the matter for all time to come. But why we are so strict on this? Because there was already an indication on the last occasion given. If your junior has not indicated you that what transpires from the judge, from the bench, I am really sorry that you have not been given a correct picture. You have not been given a correct picture that the court will not adjourn this matter under any circumstances.
That's the communication gap. But, at least, madam, can you make it on Friday?
দিন ধরে কতদিন ধরে এখানে আমরা করে যাচ্ছি। Many a times the recordings are not done, but it appears the earlier bench also.
That is correct.
And then on that day, it was say the original will is not there, adjourned. On that score, it was adjourned to bring.
Lord, so far myself is concerned, I can say whenever your lordship will give me an accommodation, I can conclude my argument. So far myself is concerned. But the difficulty is this. Lord,
Mr.
Mr.
Banerjee,
Bhattacharya-
I appreciate it. It is not that I do not know you from that side also.
Lordship.
If you prepare yourself, you will conclude the argument.
Yes.
I'm quite conscious. There is no difficulty. But the difficulty lies somewhere else. Either Mr. Bhattacharya has not communicated to you that you have to argue and you have to complete it, because he was there on the last occasion and it was indicated that I do not want, you'll have to come and argue this matter. If you want to engage a senior, there is no difficulty, you can engage. We appreciated his predicament not to proceed with the matter because the senior who was engaged yesterday, I mean the day before, he returned the brief. So his predicament was appreciated by us.
Lord, justice may be tempered.
But it
with
does not
mercy.
mean, no, the
Mercy.
justice
May be
cannot be a
tempered with
one-way
mercy.
traffic.
Lord, always
The
is no
justice
doubt.
cannot be a one-way traffic.
No
The
doubt about
justice
it.
must be
But in the
imparted
facts and
to
circumstances
both the
of
sides.
facts and circumstances of the
So-
case, my lord, this is the nature of the case, my lord, in which my client has been totally deprived.
No, the
the
only
property.
thing is
What is
because
this? No, my lord, that's not correct.
Ex party.
His client is enjoying the hotel with a bar.
Oh, no, this is beyond
Kindly
record.
produce your will.
Beyond
Kindly
record.
that
Beyond
what you
record.
said is also beyond record.
Mr. Mukherjee
If it is
saying-
beyond record, then Mr. Banerjee, what you say that your client has been deprived is also beyond record.
My lord, we are proposing to file.
Due to 148, they have acknowledged the existence of the will, 148 in the paper book. Before your lordship acknowledged it, page 148. Respond number 4 and respond 5.
Quoted to the bar.
Yes,
Everything is here, nothing about the court below.
this is recorded by your lordship, my lord, while passing the order of injunction. J to 147 and 148.
You kindly show, place it of the Hon'ble Court.
Great.
Yes, yes, we have seen that.
Yes.
No, no,
They have
because,
acknowledged it.
because Mr. Bhaskar Ghosh, my lord, appeared. All on a sudden he retired. That is the whole difficulty.
So,
No, that is the whole difficulty.
no,
my
no,
lord,
why
cropped up.
difficulty? What
That
transpires
is the
from
whole
the record?
difficulty cropped up for Mr. Bhattacharjee.
No, it's not difficulty. He has pointed out that on the day when we disposed of the interlocutory application, you made a submission and submission was made from
But
your
so
side.
far, myself is concerned, I can assure your lordship on that day I can conclude. Whatever argument I can advance, I will not take any adjournment.
আমি তো পাচ্ছি না এদেরকে আটকাতে।
That much I can tell your
But
lordship.
I am not happy. I can say I am not happy.
Because of the past event, my lord, which is not known to us, my lord, suddenly
No.
should be unhappy.
No.
It is not known to us.
Lord, fast appeal, my lord, at least, my lord, hearing should be given to the council.
What we are doing for so long, Mr.
that is why-
Banerjee,
why
hearing
not-
should not be
I am
given.
not
We are
prepared.
ready to give you a
Lord, I
hearing.
am not prepared. Kindly
We are
record in
ready
the
to
order
hear
that
you.
I am not
What we are
prepared.
doing.
Then kindly record in the order that I am not prepared. And your lordship is not agreeable to accommodate the council. Immediately your lordship pass an order. I don't mind for that.
This is an unfair submission. Unfair submission.
We are
But your
recording it.
lordship will.
We are recording it.
But your
Mr.
lordship
Banerjee will
give the
record it.
accommodation.
There is no difficulty.
No.
We'll
Lord,
record it.
I am saying that your lordship will not say that. Lord, my submission is your lordship will not
But
say
why
that.
Mr. Bhattacharjee has not told you? That on the last day, the court says no further adjournment, you'll have to do the case.
Lord, that is
If
the
your client
communication
cannot
gap.
engage a senior, then you'll have to argue the matter.
That is the
It was
communication
indicated to him.
gap. Otherwise, I ought not to have taken the brief. That is a
It was told to him
communication gap. Yes.
that you'll have to
And
argue.
I ought not to have
Whatever.
taken the brief, my lord. That is the whole difficulty, my lord.
We appreciate,
I will
because
come-
when the client wanted to engage a senior, we appreciate his predicament. His agony was there. That's why we adjourned the matter. Only for him. So that at least he is not in any kind of an embarrassment from his client. That was an accommodation given to him.
Communication gap did happen, my lord.
No. These are all, may I use a very harsh word? I have a harsh word for that.
No, don't use. Try to resolve this problem. Due to communication gap, we could not make ourselves ready. I also briefed you yesterday. Had it been this story, I could have accepted.
আমার তো
এত কিছু হয়ে গেছে।
আর আমি নিতামই না ভেবে।
আমি চেষ্টা করেছি যে কোনো রকমে
এভাবে নেওয়া যায় না
argument.
হঠাৎ কেউ এসে ঢুকিয়ে দিল ব্রিফটা। আরে
That is better, at least I am embarrassed, I can say. We are releasing this matter. Let it go to some other bench.
আমরা
I'm
বিপদে পড়বো, ওরা এটাই চাইছে,
এই
এটাই চাইছে, একদম না, আমরা বিপদে পড়ে যাবো।
my lord,
We want this.
I am retired.
No.
We want this.
What is this? If the court is very accommodative and the court has given a much opportunity, and if this opportunity is being misused, I think it's really a sad day for the bench.
No, your lordship.
Really a sad day.
Your lordship,
My lord, we have to argue before your lordship.
No,
Lord,
that's
that
not.
your lordship.
No, there are other benches. You
Lord,
are,
then in that case, my lord, we could not.
there are other benches.
We
You are.
may have to retire then, my lord. Because we have to do the case, my lord, before your lordship.
Sir, only thing is that these are the matters relating to probate pending for such a pretty long time. We wanted to dispose of the matters,
That's right,
but
my lord. Yes,
look at
yes. No, with regard
if
to
we
that,
do
my
not
lord,
get
I
a
have nothing
cooperation
to
from
say,
the
my lord.
bar, then how can we proceed and
I
dispose of
have nothing to say with regard to that, my lord.
every time we request, today may be a problem, tomorrow, day after tomorrow, you please come and do the matter. Where is the difficulty? No, I tell you, I had an experience. If I commit to the bench, Mr. Basu, if I commit to the bench that I will do the matter tomorrow, then I always kept that commitment.
But I am not known to be serious. Happened.
This is what a junior's fault, if he has not communicated to you.
Now I I said this is not his fault, it's my fault.
My fault, our fault. Lord, we should not abuse our juniors, my Lord. Our fault. We should not say anything to our juniors. কদিন আর্গুমেন্ট হয়েছিল গো? অনেকদিন আছে না না অ্যাপিলটা আর্গুমেন্ট হয়েছিল হবে না এই সপ্তাহটাই পারবো না সামনের সপ্তাহে যে কোনো দাও না তো জজ সাহেবের ব্যাপার হ্যাঁ
Don't release them.
রিলিজ নো নো রিলিজ না না জজ সাহেব বলছে সেই জন্য আমরা চাইছি না we are to before your lordship. We are to before your lordship, my lord. If we lose, you lose before your lordship. If we win before your lordship.
Practically, I am absolutely not impressed with that. It's not a question of losing or winning of the case. It's a question of imparting the justice, and the justice
Right.
means
Absolutely.
a timely justice. A
Absolutely.
litigant is really waiting for his matter to be disposed of. This can't be it's not acceptable one that the please
Lord,
not said we are on live podium.
Even it can be fixed at the top, my lord, I shall conclude my argument on that day. পারবো না ভাই কালকে পারবো না তুমি একটা সপ্তাহ আমাকে টাইম দাও পুরো পড়তে হবে আমাকে বাড়ি বানানোর মামলা।
Property মামলা যাবে তুমি খাচ্ছ করা চিন্তা সেটা বলুন
Anyhow, we are unable to control the situation. We are unable to control the situation. Whatever you suggest, now we have to accept, or with enormous difficulty have to gulp. Give a date. Give a date. Give a date. Now this time we will not suggest date. You suggest date. Whatever time suits you, whatever date suits you.
Next week,
Only problem is from Friday onward, I may not be here.
Before
I'm
that,
going for a circuit bench at Andaman, so I will be there till 29th.
before that, not any day.
No, before that, 3 days are left.
Yes, any day before that,
3 days.
any day.
Wednesday, Thursday, and
Yes.
2 days are left.
Wednesday
Wednesday and
and
Thursday. Only 2 days are left.
Jetu, Wednesday and Thursday,
Means tomorrow and day after tomorrow. That's the only.
I don't think we will have no problems any day.
Please suggest
Up to my-
everybody should, you give
Day
us.
after tomorrow.
We are not going to say anything.
They will
You
try-
suggest a date.
They will try to put it
I
after.
do not know. You all come to a consensus as give it a date.
Day after tomorrow.
প্রথম দিন রাখুন
হ্যাঁ যাওয়ার আগে শেষ করো। তুমি শুক্রবার দিন করে দাও অসুবিধা নেই
থাকবেন না বলছি
জেঠু
থাকবে না 2nd October your lordship
2nd October তুমি মামলা করবে
oh sorry
Milord, they're trying to push it, Milord, after your lordship returns. Kindly do not allow that.
Fourth October.
Kindly do not, Milord, with a lot of
Saying anything, all of you, please.
we are-
take a
we are-
consensus and give a date.
জেঠু
4th October বললো ভাই দিনে পারবো
কি বলবো
আপত্তি করবেন না আপত্তি করেন না
বলো
October 4 বলছেন স্যার আমি অক্টোবর
Are please use the mic so that he can hear.
October 4 বলছি স্যার আমি হ্যাঁ উনি আন্দামান থেকে ফিরে আসবেন 29 তারিখে
this year or next year
Huh.
this year or next year
একদম this year
this year this year.
Maybe please kindly pray, my lord. যেহেতু যাবার আগে 29 তারিখের আগে এই মামলা এমন কিছু স্যার রেডি, হারাধন ব্যানার্জি সাহেব একদম রেডি।
রেকর্ডে পাতা থেকে পাতা পড়ে গেছে, প্রত্যেকটা পাতা মুখস্থ।
হ্যাঁ এক্স্যাক্টলি, হ্যাঁ।
Look at the compliment which he has given it to you, Mr. Banerjee. Look at the compliment which he has given to you. Look at the compliment.
Let us not waste your lordship's time. If it is on 4th, let us conclude it on that day.
On that day, my lord, I shall conclude. 4th.
যেটু আপত্তি করো রাজি করো না, রাজি হও না।
ওর কথা শুনবেন না, 4th রাখবেন। 4th.
যেটু তুমি একদম রাজি হবে না, যাবার
রাজি
আগে।
হইলি তো ভাই, হয়নি। রাজি হইলি। যা করে করুক ভাই, এক গ্যাং।
Thursday করে দাও।
পারবো না তো, পারবো না।
প্রত্যেকটা পাতা মুখস্থ।
না গো, না জানি পারবো না, পারবো না, ওকে পুরো পড়তে হবে, পুরো পড়তে হবে, পারবো না, আদারওয়াইজ আমি বলে দিতাম। 3 days নেক্সট উইক হলে হয়ে যেত, কিন্তু নেক্সট উইকের জন্য থাকবে না তো।
থাকলে দেখতাম ওই যে পড়তে হবে না, আর একটা সপ্তাহ লাগবে।
বলো,
রাজি হয়ে যা, রাজি হয়ে যা,
বলো।
রাজি হয়ে যা।
ঠিক করে এনে টানা যা কোর্টের সামনে আমার ভালো লাগে।
হ্যাঁ হ্যাঁ, জজ সাহেব যা বলবেন আমরা তাই মান।
জজ সাহেব তো বলে দিয়েছে, সেরে
No further action on 4th, and with smiling face, not being annoyed with us.
But
Yes.
what comes out in the open is not always what is inside. So we understand.
No, I am always open.
Always, Lord, always a
My lord-
smiling face.
My lord's angry face may not be what is actually inside. So that is also.
এবার ঠিক আছে।
এবার ঠিক আছে।
But kindly mark the third in part, that's kind of.
That's against my principle. That's against
তার
my
আগে কিছু
principle.
হবে।
No,
কনসিড করি, ঠিক আছে? 13
that's against my
বাজে
principle.
কথা কম বলো। ছোট্ট এইটুকু একটা
Yes,
মামলাকে নিয়ে তোমরা যা ইচ্ছা তাই করো। 3rd October?
All the parties are represented. The appellant has already concluded the argument. And the today, comma, the respondent was supposed to argue today. Though the broad line of the argument has been indicated, has been highlighted by the contest, by the respondent number 4 and 5, but they prayed for an accommodation so that the argument would be completed on the other day.
8 আমি ভাবলাম উঠে গেছে, খুলে দেখি তোর দিকে আবার বসে।
Though we were not inclined to grant the adjournments, but considering the fact that it relates to a grant of probate and the decisions taken in the instant appeal may likely affect the posterity to come, we give another opportunity to the respondent to argue the matter in the instant case on an assurance given by them that they would not take any technical plea to forestall the hearing of the appeal. Full stop. Let this matter be listed on 4th October to be taken up at 10:30 AM. Single word or 2 words?
When it comes to Mr. Basu, my lord, we are not sure.
Order for
Even I, that's why I asked this question.
Lord, affidavit in the meantime with regard to order 41 rule 27.
No, they have.
You shall use an affidavit in the meantime.
Way back.
There is no direction.
Lakho. In the meantime, Lakho, the parties shall exchange the affidavits so far as an application under order 41 rule 27 of the code of civil procedure is concerned.
I'm deeply obliged.
Last.
এটা করে দাও, শোনো। In the meantime, the contesting respondents are directed to file affidavit in opposition to an application under order 41 rule 27 of the court. On or before 26 September.
26.
Reply, if any, shall be filed by 3rd October. Matter is fixed on 4th.
What I'm doing? 26. It was 26.
Suddenly something is struck in my mind, so I just thought time limit is to be given.
Oh,
Time limit. yes.
again, my lord says that no technical plea can be taken. So that is a technical plea. We cannot take it even then.
Yes.
Great to lordship.
Yes, next.
11, may I please, lordship, I am for the appellant. My affidavit of service.
Why it has come before us?
My lord, this is a first appeal, my lord. My lord, this is.
First appeal is FMET.
Yes,
It's an FMET.
my lord, there is two applications on condonation of delay. There is a delay of filing of this appeal, my lord. My
Application
lord,
has been filed against an order passed by the
order
Learned
passed
EI
by
Court.
the
Learned?
EI Court.
SI court, Employees
Insurance
Insurance Court.
Appeal is maintainable here.
My lord, as per the section 82 of the Act is maintainable because the any order passed by the ESI court that should be appealed before the Honorable High Court.
Yes.
My lord, this is
Section 5.
Section 5 is there. My lord, there is a.
How many days delay?
There are 101 days delay. My- No, sorry, my lord. No, 17 days delay. 17 days delay.
Yes,
But
what
I
is
have
the-
accept, I have.
What is
explained
this?
the
Can 2 is the injunction.
Injunction, my lord.
What is this?
against an order passed by the Learned EI Court.
Condonation.
My lord,
Condonation. Delay.
The condemnation টা কিছু
What do you say on delay? It has to be condoned first.
that are all up to your lordship. Lord.
Yes.
All up to your lordship.
This is an application for condonation of delay in filing the instant appeal. Beyond the statutory period provided therefore. The instant appeal arises, the instant appeal is filed under section 82 within bracket 4 of the Employees State Insurance Act 1948. Just give me that book.
Yes, madam.
No, instant appeal is filed. কি বলেছি? Under section 82 শুধু of the Employees State Insurance Act 1948, wherein for preferring the appeal, comma, the period of limitation is provided as 60 days. Stop. It is stated in the instant application that the petitioner was all along diligent in proceeding with the instant matter, and the delay was occasioned for the circumstances which was beyond its control. It appears that because of the lapses of the clerk of the learned advocate who represented the appellant before the court below, the certified copy of the order could not be applied on the same day. Stop. It further appears that the learned advocate who represented the appellant also suffered from fever and therefore could not establish any contact with the appellants. And ultimately, when the contact was there, there was a delay of few days in approaching the said learned advocate, as the appellant number 2 is a septuagenarian and suffers from various old age related illnesses, not old age related illnesses. Illness. And ultimately entrusted the instant matter to another person so that the instant appeal can be filed before this court. So it appears that the learned advocate who filed the instant appeal took time to draft the memorandum and the application. Stop. It is no doubt true that the fact which is narrated in the instant application constitute the sufficient cause, as the litigant cannot suffer because of the act of the clerk or the learned advocate. Furthermore, the learned advocate himself was indisposed, and therefore we find that a sufficient cause has been made out for the purpose of condonation of delay. Accordingly, the application is allowed. The delay in filing the instant appeal is hereby condoned. The office is directed to formally register the appeal. Let the application it has to be admitted. Let the appeal be listed under the aiding order 41 rule 11 of the court. Monday.
But your lordships will not be there from
For the other bench.
but there is
No, before the other bench. What is this? Yes, next.
Application is there, my lord.
Unless it is admitted, how can we? It has to be admitted. It is not included in chapter 5, rule 17 of the appellate side rules. So anything which is beyond that requires an admission under order 41 rule. Monday.
Can it be taken up on?
No. Monday. Next, listed on Monday.
Deep level.
It will not be here on Monday.
So other bench is there, no difficulty. Why? Yes. Call the next. It a কোন hearing holo, it a short hearing matter. Short hearing matter.
This was kept only to cite the judgment before your lordship, whether in a suit for partition, all the properties are to be included in the schedule.
Yes. Which for the other side?
My lord, Mr. Mokaram Hassan is for the other side, but he's left the.
He has already completed the argument, or he did not argue.
While he was arguing, this point came up for consideration before your lordship. Then he submitted before your lordship and that he will cite a judgment of judgment of the Supreme Court, where the Supreme Court differs. Then one of the learned advocates assist him by supplying a judgment, and that's why this matter was kept pending.
Yes. He is a plaintiff.
No, it actually.
Yes.
Kindly take it tomorrow or day after tomorrow. Kindly take it on tomorrow or day after.
Today itself. Have you seen the note? Why you did not circulate a notice? Why you did not circulate a notice? Sorry. Call him. Yes. What are the judgments? Cite us. Cite before us.
The first judgment, I want to say 36 CWN. Your lordship, 39 CWN 1044. Your lordship,
yes.
Last 4 lines, then of the first page. Learned advocate for the appellant, however, contended that the principle applicable to transfer of portions of joint property is not applicable to transfer of a part of the joint family property of Hindus. In support of this contention, the learned advocate cited the following judgments from Mains Hindu law. Where a stranger to the family acquires a title to a portion of the family property by purchase or under an execution, his remedy is by a suit to compel his vendor to come to a partition and so give him an absolute title. But he cannot demand a partition merely as to the portion over which he has claimed. The vendor must have a complete and final partition so that all the family accounts may be taken against him, and all other members of the family must be made parties to the suit. Mr. Main does not
Paragraph 3 is the crux of the entire.
Yes. Yes.
The 3 is the Yes.
Now, my lord, the next judgment I want to cite before your lordship.
পনেরোটা property। তো সেইভাবে একটা ভেরিয়েবল ডিসক্রিপশন যদি 15 মধ্যে যদি 12 প্রপার্টির হয় তখন 2 প্রপার্টি equal distribution ওখানে আসে। This is what is paragraph 3.
The next judgment is, my lord,
That is cited here.
yes.
You did not apply your mind.
No, my lord, since it has been, my lord, elaborately, my lord, gone through in page 2, my lord, on the last but 2 paragraphs, my lord, I want to cite that the lines, the paragraph starts with the learned vakil.
Yes. Which paragraph?
My lord, next page, my lord, first page, next page.
Paragraph beginning with?
Paragraph starts with one of the learned vakil of the appellants. For the appellants raised other objections, but we need not go beyond these preliminary questions. Certain cases have been cited to us, which no doubt dealt with suits for partition of property of Hindus. But so far as the question before us is concerned, there does not seem to be any distinction in principle between partition of joint property under the Hindu or under Mohammedan law. The real objection to the suit is one of which seems common to both the classes of cases, namely that it is inexpedient to allow suits for partition of a portion of the property because it would lead to a multiplicity of suits and the endless litigation between the parties who are jointly entitled to the property. It is clear upon the admissions of the plaintiff that there are properties other than those in suit jointly owned by him and by the defendants. It is also a patent fact that the sisters Rahimunnesha Banu and Kalimunnesha Banu, who have not been made parties to the suits, in their evidence repudiate, as we have said, any relinquishment by them of the claim to a share of those movable properties, while the so-called deed for partition has not been placed on the record. Under these circumstances, it appears to us right that the case should go back in order that the plaintiff may amend his claims and make his suit one to
This
which
is what
there
is the
can-
ultimate decision.
My lord,
This is what is there, that to give them an opportunity not
Yes.
to defend,
Yes.
defeat, amend the plaint and then
Amend-
bring all the property.
yes, yes.
Yes.
And there is one unreported decision, my lord. My lord, as I have indicated, your lordship sitting with Justice Chomdo, my lord, passed the order, my lord. It is in FA 281 of 2016, my lord. My lord, your lordship passed on 8 March 2021. My lord. My lord, page 3, my lord. However, the paragraph starts with however. While taking up the suit for passing preliminary decree, the court noticed that though the addition was made at the behest of the defendant who filed the counterclaim, but shall not reap to the benefit of the plaintiff as it is restricted to the counterclaim and not to the plaintiff. It is further indicated that all the properties were not included in the plaint by the plaintiffs, though such properties find place in the counterclaim filed by the said defendant. The trial court proceeded to dismiss the suit, holding that all co-sharers were not implicated as parties and all joint properties were not also included in the plaint. Though the counterclaim, then my lord, you will also discuss about the counterclaim. Then my lord, the next page. I'm sorry, my lord.
Same thing, the same principle of 15 CWN
Yes,
to
yes.
opportunity to amend and then
Yes, yes.
this is what is given.
Only the last. Only the judgments of the apex court reported in 2009, volume 9, Supreme Court cases, page 52. Same.
Yes.
Only the first page, the matter deserves to be remanded to the trial court because all the properties that were inherited by the father of the parties by virtue of registered deed of partition dated April 27, 1954 were not included in the present partition suit. The appellant herein had taken a consistent stand right from the very beginning that unless all the properties are included in the plaint, the suit would be bad and partial partition cannot be effected. Then the court considering the same same that the matter was remanded. That is at page 58. Last but one page, the paragraph starts from page 20, paragraph 21, 22, 23, and 24.
Same thing has been done.
Yes.
Amendment and then.
My lord.
Yes, that's
So,
all.
it is admitted by the plaintiff that some of the properties that has not been included in the plaint, Mr. Mukram Hussain, while arguing before your lordship, said that here.
It's a question of remand having been done.
My lord.
And then he will be permitted to amend and include all the properties.
My lord.
And then adduce an evidence afresh. Yes. Tell him that we will remand the matter, permitting your client to amend the pleading and incorporate the other properties also, and then adduce an evidence. Yes. Hearing concluded.
No. Your lordship will also permit me to my lord, adduce the evidence, my lord, so far as the documents, I have indicated that by those documents, Mr. Mukram Sassan's client, my lord, purchased the property from the vendor, my lord, although the vendor has got no title over the property at the time, because my lord, limited interest was there with regard to the 0.05 decimals.
We'll say that will there, if you want, you can do it. Specific. Yes. Yes. Next. Can you finish within 15 minutes?
That cannot be.
Yes. Just tell us in nutshell what is the matter about. Then we will decide.
My lord, arises out of an judgment and decree by virtue of which the grant of probate was refused.
Say that the present appeal against the refusal to grant probate. So it was converted into a contentious cause. Any caveat or objection was filed by them? It was.
It was.
So what was the finding of the trial court that
lord,
suspicious circumstances?
No.
No signature match or something what?
My lord, the will was proved, but the court has refused to grant probate in view of the fact that that will give birth to another litigation.
From where they got it?
My lord, kindly look into the judgment. And my lord, the fact of the present case is, my lord.
No, why he say?
My lord, the says is on the ground that there was a previous compromise when this will was not discovered. And my lord, by virtue of that, a second appeal was dismissed. What happened in this case, my lord? One Kalicharan Satra was the original owner of the property. He has two sons. He has, my lord, by the first wife, he got one son and one daughter. And later, my lord, subsequently, he married second time, my lord, on the death of the first wife. And there were 3 children, my lord, born.
So in total 5.
In total 5.
Including, excluding the second wife.
Excluding the second wife. My lord, the Kalicharan Satra made a by virtue of a deed of settlement, settled the properties in favor of 3 sons.
Second wife.
Of the second wife.
Correct.
My lord, a title suit was instituted by the
This was
one of
deed
the
of settlement was prior to the will or after the will?
prior, that was prior to the will.
Prior to, then
My
who
lord,
filed a title suit.
my lord, the Kalicharan son, one of the son of the first wife,
he has only one son of the first.
My lord,
from first wife only one son, one daughter,
son.
as you say.
He instituted a suit praying for declaration
After the death of his father or
after
before?
the death of his father.
Achha.
That he has one of subsisting interest for a partition that he has interest to the extent of 1/5 share of the property and for setting aside the deed of settlement, which was dismissed, my lord, by the trial judge.
Correct.
Thereafter, my lord, the matter went to the appeal. The appeal court allowed the
Reverse the, so
finding and
declared the settlement to be bad
settlement to be
and
bad.
1/5 share each.
1/5 share each.
Then
Against which, my lord, an appeal was
Second appeal.
preferred before this court.
What happened?
During the pendency of the said appeal, my lord, all the original owners, they died. My lord,
These five.
Five.
Yes.
Only one was living. And my lord, during one of the son of the second
wife. Okay.
wife, he was living. And my lord, their heirs were substituted. And in the said suit, my lord, there was
appeal.
In the second appeal, there was a compromise by the parties.
Compromise. This compromise was done prior to this will or after the will?
Prior to after the will.
Has to be. That's why I'm asking. After the will.
After the will, the compromise was done.
Correct.
My lord, so far as the present petitioner is concerned, she has also a party
She
to
was
the
a party to the compromise.
compromise. Thereafter, my lord, the will was discovered. And when
By the will, the original owner gave to whom?
the original, my lord, Durgawala, the daughter.
Durgawala, I don't know. Original owner. Will of testator or testatrix?
No. The testatrix, one of the daughter who has claimed, my lord, who had 1/5 share to the property, he has gifted some of his properties.
That is 1/5 share.
1/5 shares. Out of his 1/5 shares, she has given, my lord, some of the properties to her daughter.
To her daughter.
To her daughter. And my lord, also given, my lord, some of the properties less than what the daughter has been given. My lord, less properties were given to his sons.
Son.
To his sons.
Means the daughter's son.
Daughter, not daughter's son, but she has also 3 daughters and my lord, the 2 sons.
Correct. So 1/5 share, she by virtue of a will bequeaths this 1/5 share, whatever the property she had, to one of the daughter.
To one of the daughter, all the properties were given to all of the sons and daughters, but the daughter was given much property.
Much more share.
Much more share.
Correct. Then
against which, my lord, the daughter has filed, my lord, the application for grant of probate.
Correct.
My lord, the court has, my lord, refused to grant. That will was proved, but the court has refused to grant probate because of that will give birth to another litigation.
Litigation.
My lord, that is the observation.
No. How the suit for settlement, which ended into a settlement, has any bearing?
My lord,
because
that has no bearing.
That was a suit for really a declaration that the settlement deed is void.
Void.
Which was declared by the first appellate court to be void.
Void.
Now, before the second appellate court means the high court, the parties entered into a compromise. By virtue of a compromise, they have divided the whole state. So they have accepted 1/5 share each.
They have accepted 1/5.
Or at least the share which would go to that daughter.
Yes.
Which would go to that daughter, they have accepted it.
Yes.
It is indicated.
It is indicated.
That daughter would get this.
That daughter would get this.
Now that daughter has executed a will.
That daughter has executed a will,
Correct.
my lord.
So the will is in respect of whatever she has been provided on the basis of this settlement
earlier by the court of appeal.
That's the title which flows.
That's
the title which flows. And now, if that being the position, if the genuinity of the will has not been doubted,
only
on the basis of that settlement, the further litigation would come.
My lord, only on the basis of that.
What do you
That
say?
is my lord.
How?
That will was superseded by the deed of family settlement. And
What
at
are
the-
you saying that family settlement was prior to that particular suit? Suit was filed seeking declaration that family settlement is not correct. The trial court dismissed the suit, means the holding that the family settlement is correct.
Yes, yes.
First appellate court reversed.
Fine.
Reverse
Then
saying that the family settlement is not a good one. Then the second appellate. In the second appellate, parties have entered into a compromise.
My lord.
And the compromise decree was passed.
My lord.
Means according to him,
My
by
lord,
compromise
no,
degree,
your lordship, I'll
the
consider.
parties have settled their portion.
Well, I'm telling you, lordship. My lord, deed of settlement of the year 1970.
That
Seven-
has been,
Sir, what is the ultimate second appeal? The compromise was effected when? In which year?
2005.
Correct. Settlement, whatever deed was prior to that.
It was prior to that.
Now, by virtue of this settlement,
Fine.
settlement means the compromise.
Fine.
How the properties were distributed amongst these five? Tell us. How the properties were distributed amongst
Well,
the five?
according to the share of the respective parties, a solemn of compromise petition was filed, and my lord, by entire property was, my lord, divided into some different lots. And
True,
accordingly,
then-
lots were allotted.
Correct. Now, the testatrix have been allotted.
My lord.
She has been allotted. Now, if a will is executed, then this will is in respect of that allotted portion.
No, my lord.
No,
Not that.
means
My
what?
lord, because of that, will, your lordship kindly consider, will of the year 1999, and my lord, the compromise was effected 2005.
Correct.
There was no scope. at
What
the
is
time.
scope?
My lord, so far, will was to the my lord, respective allotment, not that. At that point of time, in the year 1990, there was no allotment.
I
Allotment
am
was-
asking you, Mr. Rao, whether this can be a ground to deny the
My lord,
probate.
my lord.
Ultimately, one can go for a title suit and can claim a right that this was not there. I have got a right. Can the court deny? I'm just.
My lord, your lordship,
Whether the probate court can go into the title,
no,
decide a
but-
title?
But here in
How
this,
can you?
no, probate court cannot.
Then
But my lord, probate court, your lordship, kindly allow me to place,
tomorrow come, bring that Carapiet's case also.
my lord, your lordship, kindly.
AIR 1961 Calcutta, AEG Carapiet's case.
okay. Yes.
My lord, your lordship,
I think this was a concept of compromise and the right to claim probate under the bill.
my lord, your lordship, kindly.
I shall.
My lord, we have a my lord, first part one matter before my lord, such month. My lord, day after tomorrow, day
No,
after
no.
tomorrow. My lord,
Tomorrow.
tomorrow we shall not be able to come.
You'll have to.
My lord, day after tomorrow, tomorrow.
Tomorrow.
That matter is my lord, going on already.
Which court?
Number one, with that 13, just a month. Contract matter, item number
This
one.
is also a parted matter.
My lord,
Or
your lordship,
it is before the division bench, parted matter.
my lord, day after tomorrow, day after.
Tomorrow. Tomorrow.
Day-
No, tomorrow. we come.
Then what, after recess, or 2 p.m., 2 p.m.